Morning, Mr. Matonzi.
Yes, Chairperson, it's 9 o'clock. We do have the department, DMA, IEC, and so that we can start with the meeting, Chairperson.
Thank you very much, Mr. Matonzi. And good morning to all members of the committee.
Morning, Chairperson.
Firstly, I want to express on behalf of the family to thank all members of the portfolio committee for having extended the word of comfort and condolences messages at our time of grief. And thanks the Minister of Home Affairs for your condolence messages. Thanks the Deputy Minister for your messages in attendance during the memorial services. And thanks the IEC Commissioner on behalf of the team and the BMA Commissioner and your team for the messages of condolences to the family. And I want to also thank the whip of the committee and the Director General for joining the send-off funeral service on Saturday. Thanks to all officials and members of Parliament from various political parties for having considered to spend time with their prayers to us. And I really appreciated that demonstrate a collective team of family and express difficulties during a difficult period. I want to extend my appreciation to the African National Congress for their support and stay at the home during the period of grief. All of you members and those that you could not reach out to thank them, we really appreciate the support you have demonstrated. I'm aware that today there will be difficulties in terms of the network. Members have already identified that the weather is not good, and we'll try to work within the difficulties we are faced today of the weather. Welcome all stakeholders in attendance, as mentioned by Mr. Matonzi, and on the agenda. After a long period of constituency, this meeting will receive updates and reflect on the key areas of migration, the work that has been done since the President addressed the nation, areas observed during the oversight visit at Beitbridge, a repatriation center, and also the lessons we've learned at the Zim one-stop border post. This meeting will also receive a presentation on the matter related to the Immigration Advisory Board and the challenges that are faced by one member of the advisory board in relation to the conflict of interest as suggested by those that are complainant. Home Affairs will detail us around this matter. We'll also receive an update by Mr. Adams on the issue of private members' bill and how the portfolio committee will deal with that matter. We've received an invitation from the president or the minister for official launch of electronic travel authorization system. An invitation was extended to the chairperson. I may not be aware of other members of the portfolio committee. We have requested the whip to represent us during the official launch of the electronic travel authorization system. It will be encouraged that members of the portfolio committee are also being invited. Members, today's plenary is going to sit at 2 o'clock, and it'll be important that we talk to the presentation, not read, because we've been circulation, and we'll able to interact so that afford members of the portfolio committee to deliberate and interact with all the report before plenary sits at 2 o'clock. I will now invite Mr. Matonzi to share the agenda and members consider the agenda. Mr. Matonzi?
Chairperson, I've shared it. I'm not sure if members are able to see it.
Members, can we consider the agenda if there's any other matter? Can I recognize hands to adopt the agenda?
Thank you, Chairperson. I move for adoption of agenda.
Thank you, Honorable Tolo. Any second?
Second. Second.
Thank you. The agenda has been considered. Can you move to the second item?
I'm seconding it.
Thank you. Thank you. Can you now move to the second item, Mr. Matonsa?
Yes, from my side, Chairperson, I've got an apology from Ms. Ngobeni. She said she's attending the Basic Education Committee, and also an apology from the Deputy Minister of Home Affairs.
Thank you. Any other apologies that stakeholders want to put forward? BMA?
There's no apologies, Chair. Thanks.
IEC?
Chair, good morning, and good morning to honorable members. The only apology is Commissioner Love and the CEO, but Commissioner Love is in Zambia on election duty, and the CEO is dealing with a matter that's urgent. Otherwise, we are here.
Thank you very much. Mr. Matunzu, I get a sense that RASA, they're not in the meeting?
No, Chairperson, no, we did not invite them because the agenda was going to be too long. So we took 2 agenda items from last week's meeting.
Okay. Thank you very much. Because we're going to, all apologies have been granted. I see we're going to take longer on the 2 items of the Home Affairs. The IEC, they're likely to sit with us until 1 o'clock. Can I propose, members, that we deal with the private members' bill on the matters that relate to electoral issues, so that we proceed. And I have a reason why that we must start with the matter. Just for recap and update, so that we give guidance on how we think we must deal with this matter, so that we close it up. Can we consider that, members?
Agreed.
Okay. Mr. Adams, can we do a recap on the matter? Then we get comments, and then so that we move to other items.
Yes, Chairperson. Just give me a second to open. Eddie, have you made me a co-host yet?
Yes, I have.
Okay, sorry, I've just shared. So this is thank you, Chairperson. So this is just an updated version of the timeline I sent yesterday evening. I've just included a little bit more detail. But just to refresh members' memory, the bill was actually introduced in the last Parliament by the now Deputy Speaker and member Dr. Lotret, to amend the Electoral Commission Act and repeal the Referendums Act, allowing premiers to call for provincial referenda. And then there was a Constitutional Court order in January 2024, and dismissing an application to grant leave to return if legislation is not enacted within a reasonable period of time. And so there was an initial legal demand from the attorneys in 5 March 2024 to request progress. And then there was a lapse as Parliament went into the next Parliament between May and July 2024, but it was revived in July 2024. And the first follow-up letter came then from the same attorneys in 12 February 2025. And there was some delays after a busy schedule with other legislative programs, as well as the unavailability of Dr. Lottery to brief the committee. So we were only officially briefed on the 18th of November 2025. And then there was an additional letter following for requesting a progress update through the Speaker that was also briefed to the committee in May 2026 this year, and in which they kind of highlighted the continued correspondence with the Parliament for update on this matter, which had been postponed a number of times. So the final, we then sent the revised timetable, a provisional timetable for the processing of that legislation in June. Again, in response to requests from lawyers.
Sorry, Mamachi, if you can assist.
Yes.
Yes, again, requesting, sorry, beg your pardon.
I was saying sorry for that, and thank you. Proceed.
Yes, and so then there was an additional letter. The most recent correspondence from the lawyers after 3 or 4, 5 interactions was on 11 June 2026, giving a request for detailed correspondence on exactly how the bill was going to be processed, demanding it within 20 days, which would have lapsed in July already. So, so this is the most recent correspondence we've had legally. And then if I can just briefly go into the contents of the bill. I also sent members a brief overview of that yesterday night. Let me just open it. So this is the brief summary of the contents of the bill, just to refresh members' memory. The section 127(2)(f) of the Constitution makes provision for provincial premiers to call for referendums, and it must be done in accordance with national legislation. And so as such, there's the courts and the lawyers have identified a gap in the law, a lacuna, and there's currently no law that provides for this mechanism. And then given a court case in 2023, constitutional court case ruled that the legal gap must be addressed, and that if not addressed, applicants may seek further supervisory relief, which they have in turn attempted. The contents of the bill is empowering provincial premiers to call for referendum, while enabling premiers to declare provincial referendums via Gazette. It will also repeal the Referendums Act, which is outdated from 1983 and doesn't really provide proper mechanisms. And also, it would require a mandate for the IEC to develop regulatory frameworks, including forms and requirements for holding referendum within 30 days of the declaration. The bill indicates that there will be there'll be a zero additional cost or personnel, as well as no immediate cost to the state. However, once the referendum has been decided, there would not be they would need to be considered based on their circumstances. So the process going forward now is the committee will either vote on a motion of desirability or non-desirability to proceed with the bill. And then from there, we'll go through the normal legislative process, which includes calling for public comment and going through various versions of the bill, and as well as public participation in. So essentially, it's just for the members to decide whether to proceed or not to proceed with the bill, and then the committee will draft the formal letter of desirability or non-desirability, and proceed and then table it accordingly, and then we'll proceed with the logistics. So depending on what members decide, we then draft the letter and proceed. Thank you, Chairperson.
Thank you very much, members, and thanks, Mr. Adams, for the update. Members, this is the update on this matter that we've been sitting with for a period of time. I must say that some of the narrative on the draft update does not reflect the decisions we have taken to defer the matters. It was not a delay, but there were reasons the committee ought to interact with other matters that are programmed for the portfolio committee. And I'll give members an opportunity to comment on the issues, not on the content of the issues, but on the how we must proceed with the matter so that we properly get guidance on this matter. I earlier on last month or so interacted with the legal team around this subject matter linked to the process of the report, the electoral report panel, and other related matters that has to deal with the elections. We also had to engage with the COCTA and the select committee on the subject matter, though it resides with ourselves as a committee. It's important that we have a sense of the conversation with the other committees because they deal mostly with the same issues. Members? Hello, Ross.
Thank you, Chair, and thank you for the presentation. Chair, yes, indeed, it's been difficult to fit everything in this term. There's quite a legislative load on this committee. I think it's certainly it's been a while since we were briefed on it, and as much as it is a constitutional requirement to have or to allow the Premier of a province to call a referendum and then have national legislation that enables this provision. I think that the DA believes it's not really a contentious bill and we should support it. We do also believe that at this stage, we've just started this term and it's been quite a difficult week, Chair, in this committee, as you know. So I would just request that the actual MOD is just carried over to the next meeting. But then I would also like to hear the other colleagues in terms of their views on this bill in response to the presentation, Chair. Thank you.
Thank you very much, Honorable Ross. Honorable Ngubane.
Yeah, thank you very much, Chair. Good morning to you, Chair, and good morning to colleagues. We appreciate the presentation, Chair, on the proposed bill. There is a number of sentiments that we've seen when we're reading at the bill. I understand, Chair, that we don't have a choice. The bill is trying to solve the lacuna in law, and it's a directive from the Constitutional Court that it needs to exist. So when we're looking at the bill, Chair, there were little of some few sentiments that we were worried about. The first was the limited scope for direct democracy. As you know, that South Africa is a direct democracy where even citizens can have access to this democracy. So the bill, Chair, it had no provision for citizen-initiated referendums, since the bill only empowers the president and the premiers to call for referendums. So there was no mechanism on the bill for citizens or civil society to initiate referendums, which limits that broader participatory democracy that we always speak about. That was the first note that we saw on the proposed bill. And the second one, Chair, was that it purport centralized decision-making. The discretion to call referendum remains with political office bearers only, which potentially restricting the use of referendums to issues aligned with their interests rather than those that aligned to the public. That was the second one. And then another item, Chair, we were worried about was an ambiguity in the referendum triggers and the criteria. The bill lack of clear criteria, where the bill does not specify under what circumstances a referendum should be called and what circumstances it shouldn't be called, leaving it entirely to the discretion of the president or the premier alone, where this could lead to inconsistent or politically motivated use of referendums, which, as we see now, where this referendum currently, Chair, you will see that we'll get a lot of backlash from the public as soon as we start to go in public with it, even on the public participation. Because as things stand, this bill will be purported as like it is taking a shape of trying to make the Cape Town independent from the current, the whole South African country. That's at this stage what it looks like. So, and then on another note, Chair, there is no safeguards against abuse on the bill. It has no clear guidelines. There is a risk that the referendums could be used, as I said, for political gains or even to bypass legislation processes or even to cause the country insecurity or instability, even intelligence security risks to the government of the day. So those were the issues we noted, Chair, when we were looking at the bill. And I can't go further than the other items where there's no explicit provisions for campaign, rules of funding to say who's funding this bill or that referendum proposals. Those things need to be placed as a guide, Chair. Wes, on the last note that I saw, somewhere the bill speak about simultaneous referendum. It doesn't have limit. The bill allows for multiple referendum to be held at the same time, but does not address how to manage voter confusion, ballot complexity, or logistical challenges. So it says you can have 2 or more, even 1,000 questions on one bill. So these are the things that it could, it needs to be explicitly defined on the bill. Lastly, Chair, when we were looking at the bill, there was no parliamentary oversight on the referendum questions. So the bill does not require parliamentary approval or review of the questions posed in the referendum, leaving the significant power in the hands of the executive only, which is the president and the premiers alone. So as I've put it, Chair, earlier on, as MK Party, in summary, we have a concern about this bill at the current state where we know that it's a Concord decision, where I think it's a chairperson of the Cape Independence or what who went and won the case. Again, I'm emphasizing we don't, as a portfolio committee, we don't have a choice. It means we need to try and close this lacuna. But the way we are closing it currently, it's at a state where it will create noise in the public about a drive to make Cape Town independent. As I close, Chair, that's all my input on the current bill. Thank you very much.
Thank you, Honorable Ngubane. Honorable Mkhale.
Thank you very much, Chair, and greetings to yourself and members of the Portfolio Committee. Chairperson, just to echo on some of the sentiments that have been expressed by Honorable Ngubane. that the bill in its current formulation, it gives the Premier power, and as much as we might not oppose that, but we would want to see a situation where ordinary members of the public are also able to initiate referendums of their own. But my point, Chair, which I think it's quite important, is that the IEC, if we proceed with this bill, there's going to be serious cost implications in terms of the how the IEC is going to function going forward, because in the event that you have multiple referendums, it means there's money that needs to go into that particular exercise. So in terms of the funding side of it, I think that's where my concern is, Chair, that there's going to be serious cost implications on the side of the IEC to be able to conduct this particular exercise across the country or in any particular province. And I don't think the IEC, or currently, I mean, we're struggling in terms of the funding of the IEC, that is not sufficient to cover some of their work. So how is this going to work? I don't see it being addressed in the bill. Thank you, Chair.
Thank you, Honorable Khale. Any other member? Okay. IEC, do you want to comment? If there's any matter to comment on?
Chair, not at this stage. Thanks.
Okay. Members, we've noted all the issues. I'm getting a sense that the committee is not going to proceed with the item for now. You're seeking to defer this item and all the issues that have been raised. And all the issues that Honorable Khale and Honorable Ngubane raised are quite important. That once we've adopted the MOD, it will be subjected to public consultation. And it will be at that point when if the committee consider that, we'll then have to call back again the initiator of the private members bill, who's the deputy speaker, and a team to reflect on the issues that are raised. And also the committee make its own input or members in relation to the overall outcome of the bill, should the committee consider to proceed with the bill. Secondly, it's important that once we've adopted MOD and is subjected to the public consultation, the IEC and the demarcation board will then be given opportunity to comment on the outcome of that process and the reflection that resides with the Dr. Lotrick in terms of the processing. And that also will give us an opportunity also to link up with the current report on the electoral reform panel. And I think the powers that reside with citizens in terms of initiative of the referendums quite important, but also the cost implications of the Independent Electoral Commission, the demarcation board, to what extent will this subject matter being considered. So I'm taking a point that we are deferring this item, and I want to propose again that we then firstly work on it at MENCO with the legal team on the issues that have been raised, and see that when we come back, to consider the report. All of us who have already engaged on the process. So there are three key issues that this committee is going to sit on that relate to electoral matters, and that involves other committees, the Select Committee of Justice and Security and COGTA, in relation to this item. I would request that we consider to defer the item, noting the issues that are there and the reports that have been proposed, Mr. Adams, and we'll then further engage on it. And thanks very much. If there's no any other view around this matter, I will then suggest we step off the item and we release the independent electoral commission team. I'm sure it's clear, Commissioner Muyabza and your team.
It is clear, Chair. Thank you so much.
Thank you very much, members. Then can we move to the items, all the items that will be introduced by the minister with his delegation. We'll take all the items. Okay, sorry, for item number 3, correspondence. Let me get the correspondence, Mr. Matonse.
Yes, Chairperson. Just before the correspondence, Chairperson, is just indicate that before the minister make his presentation, that from the 21st of July, the committee has been receiving a lot of submissions, about 267 public submissions. These issues, they relate to the composition of the independent immigration amendment board. And then the majority of the submissions raise substantial, similar, and repetitive concerns: the composition of the IAB, Immigration Advisory Board, potential conflict of interest involving certain IAB members, specific concern regarding the appointment of Ms. Stefan de Bad, who practices as an immigration attorney, representing clients in litigation against the Department of Home Affairs. And then this includes the issue of Chidima, the citizenship matter. Then the main concern, as I've indicated, is that they allege that there was an actual potential perceived conflict of interest when practicing immigration attorneys serve on the advisory board while actively litigating against the Department of Home Affairs. So what has been done was that on the 23rd of July, Mr. Mavuso Msimang, he wrote a note to the portfolio committee, which I've shared with the committee, in terms of the role of the immigration board members. On the 23rd again, there was a correspondence from Honorable Ngubane, which was forwarded to the chairperson and also to Honorable Frolik, the House chairperson, raising the same issue. And then on the 25th, then the chairperson of the committee requested that we should write to the department, to the Minister of Home Affairs on the issue, just to explain or report on the matter to the committee. And then there was a follow-up letter requesting the minister to give a formal correspondence chairperson. So that's basically it. I'm sure the minister is going to talk a lot about the issue on his first presentation, Chair. And then in terms of the letters, there is a letter, Chairperson, that we have received, that the department has been invited by the Portfolio Committee on Higher Education on the 26th of July. The purpose of the meetings is for the department to brief the committee on the issuance of permits and study visas to foreign nationals to access the post-school education and training sector, as well as the progress on the implementation, on the development of the critical skills list. These are the details of the meeting, 26th August, and then from 9 to 3 o'clock at Marx Building in Parliament, Chair. That's one letter. And then I'm just opening the other one. Chairperson, this is the letter I was referring to that Honorable Ngubane wrote to the House Chair and to yourself, and also copied the Ethics Committee. This was in relation to the appointment of the Immigration Board members. The letter has been forwarded to all members to go through it, so I'm not going to go through it. Just going to another one, Chairperson. It will take some. Then the next one is the letter from the Minister of Home Affairs in response to our letter dated 25th regarding the same matter. The letter has been forwarded to all members, and then the Minister will talk to, I think, to the letter when he does his own presentation after this agenda item. Okay, then the last one. Okay. The last one, Chairperson, is the note from the Chairperson of the Advisory Board, Mr. Msimang, where he is explaining the role of the board members. Then the same letter was also forwarded to all members, Chairperson. Just before I conclude, I've also indicated, Chairperson, last week I've emailed an invite by the Portfolio Committee on Police for tomorrow's meeting at 9 o'clock. It will be a virtual meeting where the committee is supposed to adopt a report of a petition that the committees were briefed last year in September. So the meeting will start at 9 o'clock tomorrow, and then I'm still waiting for the link to send to members. That's all, Chairperson, from my side.
Okay, thank you very much. Members, any matter on the correspondence? Honorable Mokhale?
Thank you very much, Chair. There's a letter, I don't see Mr. Matonsi addressing it on the, it's from the Gift of the Givers on issues of immigration and asylum seekers and so on. So I don't know if that correspondence was received by the Portfolio Committee, but I know I was CC'd on that letter. Thank you, Chair.
Okay, no, we did receive it. I think it was before we went on recess, and then it's my understanding that the committee, when they were on oversight at Libombo, they also met with them during the repatriation period.
Honorable Ross?
Chair, if I may just get confirmation, are we now deliberating on the correspondence?
I wanted to check if there's, no, we're not deliberating, just to check if there's any other correspondence members may be aware of, want to alert the committee.
Okay, no, that's fine, Chair. Thank you.
Okay. Members, I think let's note the correspondences because we're going to receive reports from on the key issues that are related. We're not able to respond on the ethics and the COC correspondence. What we did was to write a letter to the minister to come and account to the issues that are raised by members of the public, including Honorable Ngubane, which is a matter that's now is in the committee. Will the issue of the gift of givers, I know we met with them in the repatriation center. It may not have been a sufficient discussion if they still have to discuss with the committee, but we must note that I did receive a correspondence from the Honorable Mohale through the chief whip of the EFF on the subject matter, but we did interact with them. If they still have to interact with the committee, we'll schedule that. Our understanding in Musina was that the interaction they've presented, or many organizations, let me put like that, I think there were 4 or 5, including the gift of givers, made their presentation in the committee. Can we now invite the minister to, and all the issues will flow once the presentation has been done. Minister, I request that you introduce all the reports so that when you delegate, we're going to call them. The first item, BMA, and I think there's a third item if I'm not wrong, so that you don't come back in and out, and then the DG and the chairperson, the commissioner will deal with the presentation. Thank you, Minister.
Thank you very much, Honourable Chairperson. And let me start this meeting by, again, just sharing my condolences with your family. And I think the list of people you mentioned who actually reached out and supported during this difficult period is quite heartening, and certainly from the ministry side. And I know I speak on behalf of the DM as well, who has been very supportive during this period. Please do accept our most sincere condolences. Let me also greet the members of the committee. Thank you very much for this opportunity. And perhaps, Chair, just to firstly indicate to members, as per your earlier comment, I have asked my office to just correspond with the Secretariat. If there are members of the committee who would like to join the ETA launch tomorrow, in addition to the invitation we've sent out, I would ask that they just alert the Secretariat to that so that we can arrange the RSVP and logistics for that. So certainly very happy to help all members also have a look at this new system that we're launching tomorrow. Chair, let me also greet the senior officials on the call. We have the DG Makode, we've got Commissioner Masiapatu, and we've got the chairperson of the Immigration Advisory Board leading those 3 respective delegations or items. On the latter item, Chair, as it relates to the repatriation process, that is an enormous topic in and of itself. So I think I'll keep my introductory comments short. That this has obviously been an incredible challenge. I think DG will also make the point about the scale of the work that was required. And you know, if we look at the numbers of repatriations that were done, I think the latest figure was sitting around 75,000. Really unprecedented in such a short space of time, and all the processes involved in that. DG and Commissioner and the team will take you through those, just to give a sense of what is actually legally and procedurally required for these repatriations. It's not a matter of just you know, allowing people to walk across the border, as the committee would have seen at the facility that you visited, and let me also thank the committee for that. It is quite a rigorous and extensive process, and I will just say from my side, Chair, that I think there's reason for us to be very proud as government of the work that was done in this space. No serious incidents caused by government and the work that we were doing. We know that there were 2 tragic incidents. One involved a bus accident of a bus that was privately procured. It was not a Home Affairs procurement, as well as a traveller who passed away from natural causes. But I think if you look at the scale of ferrying people from all across the country certainly building that facility in Musina within about 5 days or so, at a scale where it could accommodate 20,000 people with water, food, medical facilities, everything required for a dignified repatriation process. I think that it has demonstrated what we are capable of. I think the IMC on migration has worked very well together, Chair. And I think you see that in the interdepartmental and coordinated manner in which this was done. If you think about the work of public works, for example, but also health and social welfare, as well as the province of Limpopo specifically, but also cities like eThekwini and Cape Town, where we had very close and good cooperation throughout this process. And then, of course, Home Affairs and the BMA facilitating the repatriations themselves. So that, I think, is a very important lesson or a learning for us. And I think, Chair, I would go so far as to say that the culture change work, which myself and DM have been focused on, really starting to bear fruits. And I must thank DG and Commissioner for the way in which they led the teams in that process as well, where we have that right institutional culture, which says we have to uphold the rule of law without fear or favor, but we also must uphold the dignity and inherent human rights of every person in such a repatriation process. So that was really, I think, the high-level approach on that. Chair, as it relates to item 4, I think the presentation has been helpful in just crystallizing this particular issue. In the way I see it, in the agenda item we were sent, there's a broader presentation on the composition of the board and perhaps how it functions, which DG and Home Affairs have prepared. And then there's a more specific question as it relates to this one particular court case. And I thought it's good for Chairperson Msimang to also join us, because I think I should emphasize to members, the Minister is not a member of the advisory board. So the discussions or agenda items, etc., at such meetings, I think Chairperson Msimang will be able to speak to. But Chair, I think just at a high level, the board is composed in terms of the Immigration Act. It's quite a unique or interesting structure, and I must emphasize, of course, that the board is created by Parliament. It is in the law, where it creates this advisory body, not an executive function, not, no enforcement powers, no operational powers whatsoever, but really a sound board, where the minister is able to test ideas and get broad and diverse opinions. And I think if you look at the way in which it's put together, and as I say, the department will give some more details on that, you'll see that clearly the lawmakers, Parliament, intended to bring together a very broad and diverse range of stakeholders. So you've got everyone from immigration enforcement, of course, the BMA, but also a number of other government departments, and then sitting alongside independent members, so people who don't work for government or not necessarily directly involved in immigration matters. But I think if you look at, I think it's clause 4.2.5, very specific in that those individual members, up to 5 individual persons appointed by the minister on the basis of their knowledge, experience, and involvement pertaining to immigration law, control, adjudication, or enforcement. So I think just to make the comment that the statutory framework specifically speaks to people who have relevant real-world experience in a number of areas. I think the chairperson is well known to this committee. Mr. Msimang is the former DG of Home Affairs and therefore has experience in control, adjudication, and enforcement of immigration. I think probably one of the leading experts in that field. but also clearly a focus from the legislature in writing this law, in getting people with experience in immigration law to assist, and I would assume, obviously, to test some of the policy considerations and legislative considerations. And actually, Chair, if you look at Section 5 of the Immigration Act, it explicitly says that the board shall advise the minister on the contents of regulations, the formulation of policy pertaining to immigration matters, or any other matter relating to this act on which the minister may request advice. So I think it's clear that it's high-level issues that this board is supposed to consider and provide advice on. So one example recently was the ETA that we are launching tomorrow. We requested views from the board on the fee that we are considering to introduce for the use of the ETA, just to make it sustainable going into the future. So I think that gives you a sense of the kind of high-level policy issues that the board has looked at. But again, Chair, I think the important point is it's an advisory structure. There's nothing that compels any minister to execute any of the broad and diverse opinions that come out of the IAB. As I said, it's a soundboard and a testing ground for ideas, policy, regulations, etc., as the Act stipulates. Just to also indicate that right at the beginning there were non-disclosure agreements, which I think are quite standard, dealing with conflicts of interest and disclosures that were signed by the members. And perhaps most pertinently, Chair, and I would defer to Chairperson Msimang on this. As far as I'm aware, this structure does not discuss individual enforcement actions or individual cases, either before the court or operationally. That's not its function. It's simply moot. So clearly, the legislature, Parliament, yourselves as members, created this advisory structure to bring together people with a broad and often differing set of perspectives, so that the minister could get a holistic set of advice on different proposals. And that's, I think, how the board has functioned. But as for the specific issue of one specific court case, there would be no way in which that is relevant to the work of the board or considered there. So I thought, let me just give that high-level overview, Chair. If I may request then, and subject to your guidance, whether we could hand over to the department to just flesh that out a bit and give a broader sense of how this structure works and where it comes from, legally speaking. And then perhaps also to invite the chair after that, if he would like to just add anything on the actual operations and mechanics of the board, seeing that the minister is not a member of this advisory structure. Thank you very much.
Thank you, Minister. We will now invite the DG.
Good morning, Chairperson. Good morning, Minister, honorable members that are in attendance, and also officials from the IEC, the BMA, and of course, our own officials. I'm not sure if, Chair, the colleagues will flag the letter that was shared by the Minister. I'll just briefly speak to it. I think given the fact that I'm a member of the IAB, the chair will be appropriate to deal with some issues. So there's the presentation, Mosi, the one that is second from below on the IAB presentation. If I'm correct, Chair, the Minister has asked that we deal with this one first. The IAB one?
Yes.
Okay, thank you. So, Mosi, if we can start with this one while the chair is preparing to take the floor. Not sure if the presentation is frozen on this cold Tuesday morning.
Matons, can you try to assist the department?
Okay, Chair.
Thank you, Mr. Maton.
Chair, are you able to see it?
Yes, we can, Chair.
We can, thank you.
Thank you. I think just to recap, the outline of the presentation will focus on, and I suppose the chair will deal with the other matters. Firstly, it's the appointment of the members of the board, which the minister has already spoken to. And then, of course, the establishment of the board with regards to Section 41, in brackets 1 of the Immigration Act. And then the composition of the board and then the functions of the board. And then there was also a request to share with the committee costs that are associated with the board. So if we can move to slide number 3, then provides how the board is then appointed, as indicated in slide 2, is through public nominations. And then whoever is nominated has to sign that statement of acceptance of nomination by the nominated member. And thereafter, the minister considers all nomination receives and then appoints 5 suitable persons. In this regard, the chairperson, this regard, it's Mr. Mavuso Msemang, and good morning to you, shall then convene the meetings of the board. And then, of course, what is key is that the board then adopts rules to govern the procedures at its meeting. And as a board member, I can confirm that this was then done in terms of rules of engagement. Now, if you were to zoom in terms of Section 42 of the Immigration Act, it then outlines who's supposed to be in the board. Firstly, it's the DG, then the head of Immigration Services branch of the department, and then any other representative, at least equivalent to the rank of a DDG from any department or organ of state who the minister considers relevant. And then, of course, there are those departments that we really are of the view that they're critical, such as the Department of Trade, Industry, and Competition. And then, of course, Department of Tourism. And then, of course, a person representing organized business. And then another one representing organized labor. And these are nominations that we normally get through the NETLEC process. And then, of course, up to 5 individual persons appointed by the minister in a prescribed manner on the basis of their knowledge. So knowledge is critical, experience, and of course, involvement pertaining to immigration law, whether they are legal practitioners, advocates, and then, of course, control, adjudication, and enforcement. The minister then designates from the members of the board a chairperson and a deputy chairperson of the board. If you move to slide number 3, Mr. Matonzi, it then indicates who the board members are. They were appointed from the 1st of April 2025, comprising of the following: the DG of the department, myself, and then we currently
Recording stopped.
Do not have a DDG for Immigration Services. We're in the process of recruiting. And then from National Treasury, the Accountant General, in this case, Mr. Shabir Khan. And then from the Border Management Authority, it's General David Shilembe, who's Deputy Commissioner for Operations at the BMA. Now, there are 2 appointments that we're still waiting for. One is from State Security Agency. This must be a member nominated by the minister in the presidency. So we had someone, but that person has since been reassigned to, I think, either an ambassadorial position or consul general position. And then, of course, Department of Tourism with the person who had been nominated by the Minister of Tourism has retired. We now are waiting for a new member from that side. Then from the public, there were these nominations that we received: Mr. Mavuso Msimang, currently chairperson, and then another member nomination that came from that exercise, Kransel Andreas, deputy chair, and then James Chapman, who's a member, and then Stefani Di Saudi, the Bandi member, and then Ibrahim Zahida. And then from organized business, as I indicated, through that NEDLEC process, Marisa Jacobs, and then Ntate Maluse Poko. So that's the composition of the board as of the 1st of April, 2025. On the next slide. This then gives the qualifications as indicated in terms of the advert that went out. So you'll note that the first column then indicates where the nomination came from. And then there's the surname, the name, position on the board, the highest qualification, an immigration expert, whether you have experience or not. You'll note that all of them do have experience in terms of immigration. And then what is your current or previous role? That is also listed. So I'm not going to spend a lot of time here because Chair, you indicated that the presentation was received well in advance, and I hope members of the committee would have gone through this list as is. So we can move to the next slide, which then indicates the functions of the board. The minister has already indicated what the functions are. One is to advise the minister in terms of contents of regulations that may be made in terms of the act. This is not unique. If you look at other developing countries, other countries on the continent, they do have immigration boards that advise, including in terms of policy formulation, which is number 2, pertaining to immigration matters. And we've been receiving quite valuable advice, whether it's on the white paper, whether it's on the regulations. And the third area is to advise minister on any matter relating to the act on which the minister may request advice, and then serve as the interdepartmental cooperation forum for all immigration matters. Now, because we do have colleagues from other government departments, they do assist us in terms of intergovernmental cooperation. If we can move to the next slide. Then it's just the duration of the term of the board members. They are appointed for a 4-year term. And then at the expiry of this term, they shall be eligible for one or more reappointment. And then the minister may elect to fill any vacancy which may occur by appointing a person for the unexpired portion of the term of the member in whose place that such a person is appointed. So the board member ceases to be a member if they resign, or if requested by the minister to resign for a good cause, or if he or she fails to attend 2 consecutive meetings of the board unless his or her apology has been accepted by the board. And the last one is that if he or she becomes disqualified in terms of this act. So this is just the financial implications. And you'll recall that the Act clearly indicates that the remuneration is entitled from time to time after consultation with the DG. And of course, in this regard, it will be the minister with the approval of the Minister of Finance. So the Immigration Board was graded by the Minister of Finance as a Category A2 institution on the 15th of July, 2003, and the current rates these are reviewed time and again by Treasury. For the chairperson, it's 4,700 per day, and then per hour it's 598, and then for the deputy chair, 4,061, and then per hour it's 508, and then for members 3,779, and then per hour 472, and then of course those travel costs for non-government members are covered by the department. And then so far we had that inaugural meeting on the 7th of April. That's the only one where we had to provide catering and traveling. All other meetings in the interest of saving costs have been held virtually. So the claims that have been paid to 6 members to date, 81,930. And then, of course, that inaugural meeting is also indicated there because we had to pay for flights and then the catering. If we can then move to the next slide. The Minister has spoken about the fact that members have signed this non-disclosure agreements. So this has been done to make sure that matters that are related to the department are confined to that and to avoid conflict of interest, which is critical as well. Can move to the next slide. Thank you very much, Chairperson. I think that's how the presentation ended. I'll then invite through the Minister, the Chairperson of the board, and I think the Chair can go into detail in terms of the response that is provided to the committee. Thank you very much.
Thank you very much, DG and the Minister. Can I now invite the Chairperson of the board?
Thank you very much, Chair, and to the honorable members. I just show my face to prove that it's me, but network doesn't permit me to continue. Yes, I have been chairperson since 2025, and we have met regularly 4 times a year. We decided that we should, because there's so much work to do, have subcommittee meetings, which include members of management and those members of the board that are available. We treat these committees as part of the board. We demand explanations, accountability from them, and that helps a lot to help us accomplish the tasks that are assigned to the board. My experience is that when I saw the thing about Ms. Stephanie Tarbandi, I tried to figure out how she could possibly influence, act in a manner that constitutes a conflict of interest. I will say on the positive side, the working committees, when they discuss with immigration officials and others who are expected to discharge obligations of immigration, is to put a little bit of pressure and make sure that there is something reportable to the board. If they reach agreements about matters that need to be addressed, as for instance, the case where the courts have asked Home Affairs to do certain things regarding asylum seekers who have gone to the court to appeal against decisions by Home Affairs, is to say, please, if you don't do A, B, C, and D, the likelihood is that Home Affairs will be embarrassed again. And that's not good for the department, and it's not good for our own reputations too. The last point I want to make, and I'll answer questions, is that people in with the background of Stephanie Tarbandi are actually very intimately involved with policy making. They engage daily with the operation of the immigration system and are often best placed to identify where legislation is functioning, whether it's functioning effectively, where unintended consequences could arise, and where improvements need to be made. That advice is relayed, and it's advice to members who participate, members of the immigration branch, to make sure that they do that back. If they didn't perform, I guess there's nothing we could do other than maybe report to the minister that people did not perform their tasks. It was discussed at the board or in its committees and so on. I really try to figure out how a mischievous board member could have a chance of influencing any case in their interest. I don't see a conflict of interest, and I'd really say that that's the position that I conveyed in the letter I addressed to the Honorable Committee. I'll be happy to answer any questions that arise. Thank you, sir.
Thank you very much, the chairperson, Baba Msimang. Members, I will now invite you to comment on the inputs made by Minister, Director General's presentation, and Baba Msimang. Can I recognize hands? I'll start with the Honorable Ntolo.
Thank you very much, Chairperson. Good morning to Minister and Deputy Minister, and good morning to the honorable members and all officials present. I would like to welcome the reports and thank the department and relevant authorities for the presentation and the progress that has been outlined before us, Chair. Chairperson, I believe this report gives the committee an opportunity to assess not only the progress that has been made, but also some of the challenges that still required our attention. Chair, on Immigration Advisory Board, Chairperson, firstly, regarding Immigration Advisory Board, the report indicates that there are vacancies on the board. My question is, when can the committee expect these vacancies to be filled? I would also like to clarity on the citizenship status of the members of the Immigration Advisory Board, particularly in light of the concerns raised regarding Ms. Desirability Sadat Dubandi. Chair, I would like to understand whether her roles as a legal representative in the matter involving Ms. Chidima creates any potential conflicts of interest, considering that she is also a member of the Immigration Advisory Board, which advises the Minister of Immigration Policy on immigration policy. Last, Chair, what is the Minister's assessment on the performance of the Immigration Advisory Board since its established? I thank you, Chair.
Thank you, Honorable Ngubane.
Thank you very much, Chair. And thank you very much as well to the Minister for the presentation of the two matters, item 4 and item 5, as well as to the DG as well for the clarity presentation as well on the IAB matters. Also, thank you very much for the presentation from Mr. Mavuso. Chairperson, as a start, as an intro from my side, it seems like we're talking past each other on this matter. Chair, what I would like to highlight, especially on what Mr. Mavuso has highlighted, in highlighting that certain individual is highly experienced in legal matters of the immigration. Somehow, Chair, we need to decide if we need to strengthen the department's legal department, the section of the legal department, so that part be strong in defending the department on any legal matters as well, so that we know that the department is strong on that matters to be able to take cases and win them outstandingly so. And then, Chair, we do not have a problem, and we are not criticizing the prerogative, the rights of the minister to appoint the board. That is the minister's right to appoint the board and everything. The issue here, Chair, is only probably about few individual, 2 or 3 individual of the board, not the structure, not the whole board, not the duties of the board, whether it can advise the minister or the minister can take advice or he cannot take advice, which on its own, it creates a dichotomy that you have a board where you will decide if you take advice or not decide to take advice. But first and foremost, Chair, I want to talk on the lack of transparency and specificity. The letter of the minister repeatedly references due diligence, Chair, and conflict management, but provides no concrete evidence of example of how these processes were conducted. There are vague assurances about conflict of interest declaration and non-disclosure agreements, but no details on their content, enforcement, or oversight. Remember, there was a first question, Chair, that asked the minister and asked to provide the detailed document about these non-disclosure signatories and agreement declaration that has been done by these members. On the second, on my letter, where it speak about, I don't know who asked the first question, but it was asked the first question by one of the member of parliament that requested the minister to provide these details in relations to the relevance of due diligence. That's the second one. That's the first one, Chair. And then the second one, Chair, on my opinion, it seems like there's a defensive and dismissive tone from the letter of the minister. The letter is overly defensive, Chair. It's focusing on justifying the status quo rather than openly addressing the public's concerns. It minimizes the significance of complaints by stating that only social media posts and parliamentary questions have been received, which comes across as dismissive of legitimate stakeholders' input, which is very valid, this legitimate stakeholders' input. This input by the stakeholders, Chair, it addresses mainly 2 issues. One, it talks about the litigants entity, which is a Scalabrini entity, that these people for years, Chair, over 10 years, have been litigating the government, have been making money from the government, and boom, all of a sudden are now having huge advantages of now having inside information about their years of litigants, where they've profit on this. That's the first stakeholder legitimate input, Chair, that is put across. And then the second one is a guy, Chair, that sits in this advisory board and goes out and defend the lady, Nigerian lady Chidima, publicly. And then people in the public are asking, this person inside is advising the minister and outside is practicing this legal defense of an individual that seems to be entangled in these immigration issues of the country, Chair. And then the document, the letter, Chair, by the minister attempts to downplay the potential conflicts of interest by relying on technicalities rather than addressing the spirit of ethical governance. The assertion that litigation against the department does not constitute a conflict of interest is presented without robust ethical analysis or independent review. To us, Chair, it seems that this matter, Chair, it's really a contentious matter, Chair. And then if I go on another issue, Chair, on the insufficient detail on board composition and qualification, while the letter from the minister lists the names and qualifications of board members, it fails to explain how their expertise directly addresses the specific challenges facing the South Africa's immigration systems. There is no analysis of skills gap, diversity, or representative of affected communities. You remember, Chair, if I go to my second questions that I posed to the minister and the parliament, it was seems light, but the minister didn't even address that question. The question was saying, Chair, we have an organization called March and March that has drummed up the whole country on the 30th of March about immigration issues. But I said on my questions, Chair, the minister there has missed an opportunity of not being one-sided on the issues of the immigration addressing, of bringing even all these contesting organizations to his advisory board so that he doesn't miss even an opportunity of educating the other members of the community, of the stakeholders, March and March, and many others. I'm mentioning March and March because it's one of those popular now, currently, and many others who are against these immigration policies that if, Minister, even on these vacant positions, Minister stands an opportunity to reach out on these other organizations and says, okay, I want to hear both sides of the stories in this advisory board. I want you, March or Dudula or whoever, come on board, and you, the immigration's lawyers, come on board, debate to me on these issues so that I get both contested and holistic stakeholder views in the matter. But even still, Chair, the Minister has lost that opportunity of getting both directive of the views. But instead, we're getting the one-sided that there are people who are experienced in these immigration issues, who have been legal fundis on these immigration issues, who have been litigating the department on top of it. But the people who have went and drum up the public's concerns are not featured on this advisory board. And then the one, Chair, is the weak handling of conflict of interest. The letter from the minister's approach to conflict of interest is inadequate. It relies on the absence of formal complaints and the signing of forms rather than proactive monitoring or independent oversight. There is no mention of external audit or public reporting or mechanism for stakeholders to raise concerns, Chair. The minister's ability to accept, partially accept or disregard advice is highlighted as well as it was my first input that it's my concerns. And then, Chair, failure to address public concerns. The letter does not engage meaningfully with the substance of public complaints or concerns. It offers no plans for ongoing stakeholder engagement, transparency improvement, or reforms to address the root causes of dissatisfaction, which is you are advising on the side, you are going on the side, you are a litigant on the side, you're making money, you are profiting on the sides, whether you are using this advisory or this access to information for profiteering, or whether you are using the advisory or access to the department's information on advisory to go again and defend all immigrants, people that are trying to bend the rules of these immigrations. As an overall, Chair, in my last closing, the letter appears more concerned with defending the ministry's action rather than genuine transparency, accountability, or improvement. It fails to provide the level of detail, openness, and critical self-reflection expected in response to serious public and parliamentary concerns. The sentiments, Chair, raised in that letter is that of opposing, as an opposing government, when you are in government yourself, by involving these one-sided people that you're including off the board. And it again, Chair, purports to us, Chair, the minister, that he chooses to just bury his head on the sand and not respond to only few, 2 or 3 individual board members that the public is concerned about. That's my closing, Chair, on the matter. Thank you very much, Chair.
Thank you, Honorable Ngubane. Honorable Hala.
Good morning, Honorable Chair, honorable members. Honorable Chair, please allow me not to repeat the very same questions that have been asked by honorable members, but only to ask one question on board members. There's a point there that says one member could be asked to resign for a good cause by the minister. Could the honorable minister explain that to me? What would be this good cause for resignation? Thank you, Chair.
Thank you very much, Honorable Matapo.
Thank you very much, Chair. Let me also take this opportunity to welcome the presentations, Chair. But mine, Chair, is also that I've been extensively covered by Honorable Ngubane, and I would really not want to repeat, but I share the same sentiments and I echo the same sentiments. I would definitely like to ask this to the Minister, Chair, that if the board's recommendations are not binding and the Minister is ultimately free to accept or reject them? What mechanisms exist to prevent the board from becoming merely a consultative formality? How do we measure whether its advice is actually influencing immigration policy and improving decision making? And as well as there's an outcry about certain individuals on the board who are sitting on the board chair. I don't think that can go unaddressed, because the matters that are coming up is the conflict of interest that is mentioned. There's a huge outcry of that, chair, and it cannot go unaddressed. It cannot go unignored, because the public needs clarity from the Department of Home Affairs and as from the minister as well. And I'd like to pause there, chair. Thank you very much.
Thank you very much, Honorable Ross.
Thank you very much, Chair. Chair, I think it's important to carefully consider public concerns when they are addressed to us. And bear in mind, we've also had public participation on the Immigration Act 13 of 2002, which covers the process and the composition of this board. Who qualifies? What is the process of somebody being appointed to the board? And what I don't see here, Chair, is any actual evidence of wrongdoing. And it's very important because South Africa's Government of National Unity formally committed to evidence-based policy and decision-making as a core foundational principle of its statement of intent of the Government of National Unity. So we're in a government and a dispensation which is based on evidence-based decision-making. So Section 42AV of the Immigration Act, it contemplates the appointment of up to 5 persons because of their knowledge, experience, and involvement. And involvement is a very important word there, Chair, in immigration law, control, adjudication, or enforcement. So private immigration practitioners therefore fall within this category of persons whose expertise Parliament intended the minister to draw upon, and this legislation was put into place with public participation of everybody around the country who had the opportunity to raise concerns about potential conflicts, etc. And so the department's appointment announcement, it describes the 5 members as experts selected for their immigration law knowledge and involvement. And the mere fact that an independent IAB member practices immigration law or represents clients against the department does not render the appointment unlawful at all. It is not, there's no indication that the process of appointment was irregular or that the practitioner here is not allowed to practice law. Again, the wording of the provision is involvement, knowledge, experience, and involvement in immigration law. Because your alternative then, if you want to take this away and not have practicing practitioners, is that you might have some academics or retired immigration practitioners that are not practicing law currently. And as much as they would have valuable expertise and so forth, they wouldn't necessarily be exposed to the day-to-day development of immigration law, which is a very complex field. So what we've seen is that the appointees serve in a non-executive role. They are advisory. They don't have any executive powers. They don't make administrative or executive decisions. And what it means is their insights are used solely for macro-level policy correction. And this is according to the law of this committee that was subjected to public participation of the entire country. And so, Chair, it's very important that an investigation, for example, should not be triggered because a person appointed is an expert that continues to work in the field where that person's expertise was acquired. Otherwise, professional knowledge becomes a disqualification rather than a qualification, Chair. So, I think what is critical in terms of evidence base, if you receive complaints, they should bring proof that the person against whom allegations are made or broad allegations are made, it should bring proof that the person advises the minister or participates in deliberations that concern a specific client or an active case or a closely connected policy issue. that that person obtains non-public departmental information that's capable of benefiting a client, or uses the position or access to influence to advance a client's interests, or participates in formulating advice that would materially affect litigation, or fails to disclose a relevant private interest or accuse herself where appropriate. So I haven't seen any evidence that this has happened. There's no evidence of wrongdoing here, but this is what is required for a complainant to be able to come in and say, here is a legitimate complaint that requires investigation. And so, Chair, I propose that the committee records the concern, but reserves any potential action for concrete evidence of non-disclosure or improper influence or personal benefit, Chair, because it's critical that we get the very best advice at a macro level in terms of our immigration system, which is a very complex system requiring very high levels of expertise to deal with those issues. Thank you, Chair.
Thank you, Honorable Ross. Honorable Mudisim, sir.
Thank you very much, Chair. Chair, I think I also align my views to those that were expressed by Honorable Mtolo and Honorable Ngubane. But I think first, Chair, I want to make an emphasis to what has been expressed, that for me, the conflict of interest in this regard relates to the financial or other private interest that could directly or indirectly compromise the performance of a public servant's duties or reputation of a public servant's department in relation with stakeholders. Mr. Msimango, when he made his comments, he made mention that he sees no opportunity of a conflict of interest. And having had made that comment, Chair, I want to really pose the question to him that, does he honestly feel that Ms. Desaude, who is currently representing a member of the public that is in litigation with the Department of Home Affairs, where she is an advisor to the minister who leads that department, that he really thinks that there is no conflict of interest? On whose benefit will the advice that Ms. Desaude would provide to the minister vis-a-vis to the clients that clearly she represents on issues of immigration in this regard? Who would she side on with, and who would she, on whose interest will his standing be, taking consideration that financially he also benefits from the fact that he legally represents members who subsequently pay legal fees towards her directly. Secondly, Chair, we are not interrogating any wrongdoings with regard to the processes of appointing the board. And as it has been expressed that members of the public are also have concern, and we share the similar concerns with them in this regard, particularly with Ms. Desaude. Therefore, the notion that we are looking for any wrongdoing towards or any unlawful act that the minister might have taken with regard to appointing the board, that is not an interest where we are right now. We acknowledge the act that guides the minister in appointing the board and the powers that he are vested with him in doing that. And we believe that in this regard, he might have then considered all the issues that are vested with him, or the powers are vested in him into being able to appoint the board. What we are questioning here is the conflict of interest, particularly with this member that we are having issues currently of immigration, where Mr. Dima is litigating the department. Does he really believe that, and the question would be that the minister, does he really believe that, or he is not concerned with regard to the standing of this person? But secondly, Chair, to check if the minister has also went out there and sought some legal advice on the concerns of a conflict of interest in this regard. Also, how does the minister then reconcile the membership of Ms. Desaude on the IEB and her role as a representative to Ms. Chidima? One member here would have also asked that the presentation does not also provide us with the citizenship or the nationalities of the members of the board. I think if we can also be furnished with that in this regard, so that we can have an understanding of who are really these members who have been appointed on the board. Lastly, Chair, it's on the issue of the financial brief presentations that we had, just to check with the minister that how many meetings have the board conducted since they've been appointed. I take note of the DG's comment with regard to that most of the meetings were conducted virtually. It may then speak to that little financial impact that it had on the board that has been spent by the department. But if we can be furnished clearly with the number of meetings that the board has been able to conduct thus far since they were appointed. Thank you very much, Chair.
No, thanks, members, and thanks very much. Mr. Matapo, I see your hand. I'm not sure it's a follow-up.
Thank you very much, Chair. Now it's an old hand, Chair. Thank you.
Okay. There's a Zoom user. I'm not sure who's the Zoom user. Mr. Matonzi, who's the Zoom user? Is a member. Maybe it's trying to log.
Chair, I don't know who's the Zoom user. If he or she can identify herself to see if it's a member. Maybe Chair, it was by mistake.
We can account to the Zoom user. Can we? Yeah, I don't know. There's a Zoom user for the last time. Can you mute?
Chair, I'm not sure. Hi, Chair.
Or it's Ona Mohale.
Oh, okay. I'm not sure because I changed devices, so I did not check if the name is reflected there.
Yeah, proceed. You can
Because I had to.
Yeah, it's set Zoom
Oh,
user.
all right.
Yeah.
Oh, okay. No, thank you very much, Chair. Chairperson, I think the issue that we're dealing with here, it's in the public, so it has raised a lot of debate among members of the public, and correctly so. But I think fundamentally what it speaks to, Chairperson, is issues of the composition of the advisory board in its current constitution, how it's constituted. And I think members of the public have been raising that around the participation or the involvement of Scalabrini and lately now with regards to Ms. De Souza. So I think that's something that as the committee, we perhaps need to look into going forward in terms of how this particular board is constituted going forward, not just only because it relates to this specific issue. But we all know currently that issues of immigration are very contentious. They have occupied a particular status currently within our public discourse. So such matters, Chair, we can't just be dismissive towards them. It's important that we address the public and we deal with the issues that they bring to our attention. Issues of conflict of interest, Chairperson, even the perception of it, that there's a perception that there might be, whether it exists, substantively or not, but the perception of it, it's important when members of the public perceive that there is something of that sort. I think it's important for us to be able to engage with it more concretely and substantively and address it and not be dismissive as the letter of the minister is saying. I'm interested to hear the response of the minister with regard to the particular clause that deals with the good cause, that the minister has powers to can release a member of the board on that specific basis of good cause. Whether in this particular instance, the minister would consider invoking that particular clause. Thank you, Chair.
Thank you very much, members, and thanks for the contributions and the comments around this subject matter. I think members have covered all areas that we invited the minister and the chairperson to interact with. Just for re-emphasis that the process of the appointment of the board and the technicalities that are brought before this before the committee is not an area where we are attempting to get into. This subject matter is informed by the role that the institution, the member of the board, is representing, and also being part of the advisory board of the department advising the minister, that potential conflict of interest has been established, as members have highlighted by members of the public, and also the submissions that have been brought before the portfolio committee and parliament. That is an area where we have interacted with. And I think it's correct that we must not, the department or the advisory team led by Ubaba Mavuso, attempt to defend where the witnesses that have been observing in relation to the current roles of members of the board, which might potential to create conflict of interest, are being presented before the portfolio committee. And I think that's the important part that we've established. Secondly is that we'll not only sit on this conversation, we'll also explore our legal team of parliament to detail clarity on the issues that we've established with members of the community and stakeholders in terms of, does the conflict of interest exist? So that our formulation in terms of recommendation is informed and clearer to what you also been interacting. Honorable Ngubani and Honorable Mutise and Honorable Mukhale also raised those key areas in terms of the powers of the minister to interpret the good cause of member of the board that exercise his or her right to the department and also the institutions that they've been representing. I'm sure you'll be aware that this institution has been in litigation with the department for a period of time. And we've been including even the members of the portfolio, the committee, on some of the legislative paths that we have been taking through. And that is a conversation that I think the minister may need to grapple with, in the chair and the DG, in order to make sure that we deal with that. We correctly have to move to seek this guidance in terms of the posture that the committee must finally deal with it. Whether the recommendation will come as a proposed for the amendment or the legislation that we may need to take to, or we may need to recommend for the release of the member of the board that has been identified as creating a potential conflict of interest. So those are some of the issues that I think members of the committee are reading the conversation around this subject matter. It's not a matter that we're going to live up to, but will afford the minister and the chair and the DG to comment on the platform, so that we have process forward on this issue. DG?
No, thank you, Chair, and thanks, honorable members, for the comments and the questions. I think just to indicate that for the two vacancies, Honorable Mudola, we're waiting for both the minister in the presidency to respond in terms of filling that vacancy that has been vacated by the DDG that was at SSA. And similarly, the minister has written to the Minister of Tourism with regards to the other vacancy of a member that is retired from Department of Tourism. Suppose Minister and the Chair will deal with the rest of the questions. Thank you.
Thank you, Chairperson of the Board. Baumsima?
Yeah, thank you very much, Chair. I guess the strongest point to me, that message that comes across is perception, that we must be sensitive to perceptions. I sincerely, and I mean really sincerely, do not appreciate the case for a conflict of interest. When people go to court and win, it is the judicial system that decides whether, the litigant is guilty or not guilty. I think the easiest thing would be for people in this profession to remove themselves from the board. I think the honorable member of the DA, I don't see his name here, makes a good point when he says it's an area of expertise that's really necessary for the board. Maybe take retired people to remove the perception, but it would be a loss to the board to not have people with that expertise in this. I repeat, in terms of conflict, it's up to the minister, of course, to decide to invite March on March and other people. Their activities do worry a lot of non-Home Affairs South Africans, very, very much so. But that's a matter for the minister and the portfolio committee to decide. So I'm saying, in short, people who are working in this area, where Delbandi and others are, provide very valuable input into the board and into the department. Maybe if there is a perception, never mind the reality, that their presence causes a conflict, then the decision might be made to withdraw them. Thank you, Chair.
Thank you, Minister.
Thank you very much, Chair and honourable members, for the discussion and the questions, etc. I think the chairperson has also assisted from his perspective. Allow me to try and cover as much ground as I can on the questions. I think one of the themes that comes out of the discussion for me is the simple reality that it is Parliament that created this structure. It is not any individual minister. It is certainly not the Department of Home Affairs. And it is Parliament that very explicitly in 4.2 of the Act prescribed the relevant criteria. And Chair, it would be incorrect for a minister to disregard those criteria. And I think we've covered those criteria to some extent as it relates to knowledge, experience, and involvement pertaining to immigration law. It's very, very clear from the wording in the Act that Parliament contemplated people who are actively involved, who understand the issues at play, and specifically even from a legal perspective. So those are the parameters that Parliament created. And to say that those must in some sense be disregarded or broadened arbitrarily by a minister in order to bring in people certain a member may want. It's not actually in compliance with what the Act says. So my view is that the minister, any minister, should act in accordance with the parameters set by Parliament, and it is obvious in this case, on a plain reading, that has been done, Chair. And so I appreciate the comments in that regard. I think the second point to emphasize is there's an irony to this discussion, because the department holds a diametrically opposing view on this particular court case from this attorney. In fact, the department is in court against the attorney. Now, that is not how a conflict of interest plays out with respect, Chair. A conflict of interest would not result in people squaring off in court. It is precisely because the department disagrees with the particular view of the attorney in this matter that it is in court. And so therefore, I think that demonstrates in the most concrete manner that there is a disagreement, and that the interests, that there's no conflict of interest because of that. I think also to just add on that point, that if you look at what the law stipulates, it is seeking those independent views, Chair. And I think you can argue that the robustness and the independence is on display, because once again, people have views. The department and certainly the minister doesn't necessarily agree with the views, but people are free to exercise those views in an independent manner. Once again, I think living up entirely to what the Immigration Act demands of the minister and envisions in the creation of this board. So there was a question on filling of vacancies, Chair. DG has indicated, again, that these vacancies are not arbitrary. They are stipulated. And in this case, certain departmental vacancies, I can share with the committee that I've also requested a member from Employment and Labour to be designated. But I agree that those vacancies should be filled with Honourable Motolo, but they must be filled in terms of what the law says. It's not correct, as Honourable Ngubane says, that we can bring people from civil society into vacancies that are clearly stipulated for departmental representatives. On the assessment of the performance of the board, Chair, I think this board, if you look at also the small amount of money even that is spent on it, it's adding huge value at very little financial cost. It is actually interrogating very fundamental issues. And as I said from the start, or I suppose it is a bit unfortunate that the conversation doesn't actually fully appreciate the diversity of voices on this board. Organized business, organized labor, departmental representatives from across the state, BMA, Home Affairs, as well as a minority of independent voices, all coming together to provide advice and guidance on or views on something like the white paper, on this ETA fee that I mentioned. It's adding huge value to the country. I agree with Honourable Ngubane on strengthening the department's legal capacity. I think that is a really important point. And I think that the irony is it's precisely people who are experienced in litigation and legal matters that have the best ability to provide advice and insights on why the department loses so many court cases, why the department is in court so often. And I think this is a point that Mr. Msimang has also made, and just again obviates against the argument that we should not have expertise who have their own views. That's not the point of what I think the law intended. Chair, I think the difficulty on some of these hypothetical questions is important to just point out. The question about hypothetically what is good cause, or almost this requirement to prove a negative. So what I would say, Chair, is if someone has concrete evidence, if someone can articulate actually what is exactly the evidence of any kind of misconduct, we will absolutely deal with it, Chair. But a board constituted in terms of the Act that complies with all the legal prescripts, where people bring independent advice exactly as the law requires, is not an allegation or evidence. And I suspect, Chair, that is exactly what the legal advice will point out to the committee as well. So it's difficult to respond to hypotheticals, Chair. It's difficult to prove negatives. If there's anything concrete and specific that anyone has in terms of evidence, that is what we are most happy to deal with, always. But there doesn't seem to be a there in this case, Chair. There was a question about the board's recommendations not being binding. I think this is from the Honourable Matopa, and what mechanisms prevent it from being just a formality. It's a question for Parliament, Chair. Again, it is Parliament that wrote this Act, not myself or any of my predecessors in this position. It is presumably a question that Parliament would have considered as part of public participation, and similar to how it constituted the board. It would have presumably considered this matter. And I think for me, it's clear that Parliament intended the minister to have access to a range of different views subject to specific expertise and specific criteria. And I think that is the spirit in which we have tried to approach this matter. And so, Chair, I think looking at the remainder of the questions, I would really just try to conclude it by saying that the rules or framework or criterion in this case were not invented by the department or by the ministry. They were written into law by Parliament. I think it is clear from the discussion that there's compliance with what Parliament intended, even to the extent that the independence of these independent members is honored and understood and is being harnessed to bring the kind of independent advice. But advice is what it is, Chair. It is not directive. It is not operational in nature. It does not run any aspect of the department's work. It certainly doesn't take decisions on legal matters. And again, that is as Parliament intended. And I think finally, Chair, to emphasize the point that it is precisely because there is a disagreement. It is precisely because the interests are not conflicted that this matter is being dealt with in court on differing sides. And again, it is up to Parliament to consider the way forward on what the law says. That is the domain of Parliament correctly. But my submission, and I think the submission in assessing the work of the board itself, can only be measured against what the law actually says and requires, and whether there is work underway to live up to that standard. I would submit that is clearly the case, Chair, and that we have indeed brought together a very broad and diverse group of people to make inputs and act as a sounding board and provide advice, and that advice is then considered, taken up or disagreed with, as the case may be, exactly again as the Immigration Act envisioned. And so you have the commitment from myself and from the team that we will continue to act on exactly the parameters that Parliament itself determined, until or unless Parliament chooses to alter those parameters. And I think that is really, for me, the core of the matter that we are dealing with here today. Thank you very much, Chair. I would be happy to hand over back to you, and you can guide on whether you want any other perhaps comments on the next item from me in addition to what has been said. Thank you, Chair.
Thank you very much, Minister, and
Chair of the Board, and the DG on your responses. What we'll do, firstly, just for noting that the Immigration Acts that you are referring to, and I'm sure all of us will know that is an initiative of the executive bill that comes from the executive, which was processed by Parliament, and also members of the public find an opportunity to comment around that process, and Parliament consider. So I thought that I must just refresh so that we take collective responsibility on the items that we're dealing with. Secondly, is that we will formally engage with the submissions that have been highlighted by Mr. Matonzi, and possibly a referral to the stakeholders and the parliamentary legal team to advise the committee in relation to the matters before us and how we must proceed forward. As we stand, the conversation of the portfolio committee members does indicate that there may be a potential of a conflict of interest by a member who is acting on both sides. And we're not ignoring the facts that have been raised by yourselves in your response, but we'll establish that with the parliamentary legal team. And we hope that when we come again with the to interface in committee to determine what process we must take forward. The other matter also is to establish how we can amend some of the provisions in the Immigration Act to mitigate such matters should they exist in future. But this is a matter that is out of our interest. We're not going to avoid it. We're going to engage with the submissions that have been highlighted by Mr. Matonzi from various stakeholders, including yourselves at the Department of Home Affairs and the board, and also the Parliamentary Legal Service. So Mr. Matonzi will process these two items in the main, so that we have an in-committee to deal with this subject matter. And we invite the Parliamentary Legal Service outside the Obama Vuso's team and also the Department of Home Affairs. We may need to have a time frame around this subject matter so that Parliament also has a responsibility to respond to South Africans who are representing, who have raised this subject matter about a member who represent both the department but also the institution that is he has been assigned to work from. So we'll work on it and come back before the end of this month, Mr. Matonzi, to reflect on the subject matter in an in-committee meeting, and also invite the stakeholders to articulate so that an informed position in terms of the collective work of the committee and recommendations, and also noting some of the issues that have been raised by all of us, and including the DG and the Minister and the Mr. Mavuso. Thank you very much. Is Mr. Matonzi clear around how we must proceed?
Yes, Chair.
Thank you very much. Can we now move to this third item? I will invite ministers articulated on the three items. Can we invite the Director General?
Thank you, Chair. I'm leaving.
Thank you very much, Chairperson, and honorable members. Good morning once more to the Minister. If we can have the slide on a presentation mode. Chair, I take guidance from what you said earlier on with regards to the fact that you have had this presentation for quite some time. Safe to indicate that we did send a revised one with updated stats. So this is the outline of the presentation. Will provide some background and context, which we did as well when you visited the temporary repatriation facility. And then, of course, the stats on the repatriation and deportations, and then the work that we've been doing with the Department of Justice and Constitutional Developments with regards to the dedicated courts that were set up to assist in this regard. And then in the questions that we received from yourselves, there was also an ask that we need to provide details around those that have been declared undesirable. And then, of course, critical as the financial implications and then the recommendations. So if we can move to the next slide, the purpose is really to provide an update on the repatriation and deportation of foreign nationals. And then the next slide, which is really the background slide, I'll spend a bit of time here because this then grounds the context. Chair, you will recall that in the 2026 State of the Nation address, which was delivered on the 12th of February, the President did highlight two issues that were flagged as the security and economic risk. Amongst them, it's issues around illegal migration. Subsequent to that, the President established an interministerial committee to drive coordination with regards to this matter, which is currently led by the Minister of Justice and Constitutional Development, Minister Kubai. And then, of course, on the 3rd of June, Cabinet then approved the comprehensive approach for managing migration. And then on the 7th of June, 2026, the President did address the nation and outlined the 5-point plan to the nation with regards to how we're going to manage matters related to migration. And therefore, in that context, the background that we've provided indicates that as a relatively developed country, South Africa does attract migrants. And of course, this emanates from issues that are related to governance, issues related to instability, issues related to unemployment in other countries on the African continent, and of course, others that encourage migration. On the same slide, we do highlight again that we do, in our approach on the management of migration, it is grounded on our constitution, and we indicate that there are those rights, Chair, that are embedded in our constitution, and of course, those that relate to equality, human dignity, and those that apply to everyone in the country, including foreign nationals. And of course, there are those that are limited to South Africans. And then on the same slide, we also indicate that as a country, our policy approach is also influenced by the 2019 National Action Plan on the NAP to combat racism, racial discrimination, xenophobia, and related intolerances. You will recall, Chair, that in 2001, we hosted the World Conference Against Racism, Xenophobia, and Related Intolerances in Durban. Emanating from that Durban conference, the United Nations in 2002 then adopted what is known as the Durban Declaration and that program of action, which was then subsequently adopted by the UN. If we move to the next slide, it's just to indicate that what the Cabinet approved was this 5-point plan anchored on these 5 key areas. One, it's really to enforce the law. The second one speaks to how do we then ensure that we secure our borders. The third area speaks to strengthening the immigration system. The fourth area, closing the gaps in laws and policies. And of course, how do we then work with other countries on the African continent? So under enforcing the law, Chair, there's activities that are currently underway in terms of cracking down on violations of immigration laws, but also labor laws. And this work is led by our own Deputy Minister, the Deputy Minister of Employment and Labor, and also the Deputy Minister of Police, as instructed by the IMC. And then, of course, it also speaks to us deporting undocumented foreign nationals. And then with regards to securing our borders, the work that the BMA Commissioner will speak to includes, amongst others, deploying capable technologies to deal with issues related to migration, and then including the use of drones for surveillance. And then in terms of strengthening the immigration system, there's work that we currently are doing, including on the legislative bill that is required for the white paper on citizenship, immigration, and refugee protection. And then, of course, ensuring that we enhance compliance and enforcement. And then working with others, we're also looking at how do we then close gaps in laws and policies, issues that the earlier discussion, amongst others, focused on, including strengthening the legal and policy framework. And then, of course, Minister Lamula is working with the rest of the continent in addressing issues around regional cooperation, because our own view is that if you do not address the push and pull factors, they will continue to drive migration. And therefore, given the advantage that we have now as we host or we take over the SADC chairpersonship, these are forums that we will be raising such matters. And the Minister of DERCO has also been crisscrossing the continent, whether it is in Ghana, whether it is in Nigeria, and other parts of the continent, including hosting for the first time the Foreign Ministers SADC retreat, where, amongst others, there was sharing of information, but also critical to ensure that there's coordination on migration management. Chairperson will only be able to succeed if we have a whole of government coordination, and this work is being led by the IMC on migration. But critical is to make sure that we have partnership with provinces, with municipalities and other stakeholders that we've been engaging. And then, of course, our approach is also, as we indicated, human rights and then, of course, the humanitarian principles that we've adopted. And then, of course, critical is to make sure that we make decisions based on data, including the work that we've been doing around monitoring. And of course, at the bottom, we do indicate the human rights approach and, of course, the obligations that we have in terms of the UN Convention of 1951, the work that we've been doing with regards to the Mosina Temporary Repatriation Center, the assembly points, the facilitation of repatriation, and then the emergency relief that was provided in line with our Ubuntu and Pan-Africanism values. And then, of course, how do we move towards enforcement capabilities, including ensuring that Home Affairs has the appropriate capacity. You would have noted we have recently advertised at least 301 positions to capacitate our inspectorate area. And then on the next slide, we speak to the principles. I'm not going to repeat quite a lot of them have been articulated in the main, but we are guided by these principles that will ensure that there's the rights of all people must be respected, and issues around human dignity and the fact that every person, citizen or foreign national, must abide by the Constitution and the law, and that everyone who lives, works, or runs a business must be lawfully permitted to do so in line with the prescripts that the municipalities provides, and that only authorized officials may act against violations of the law. And therefore, the last point is to re-emphasize that every country has the right to manage migration and secure their borders. But there are also actions that the IMC has indicated will not be accepted, such as people that are unauthorized, that demand documentation or proof of nationality, blocking access to clinics, hospitals, schools, and other public services, violence and intimidation against foreign nationals, issues related to racism, xenophobia, Afrophobia, and of course, every other form of intolerance. And then critical is to deal with issues around misinformation, incitement, and fake news that spread on social media. And then, of course, we're cracking down on employers that are exploiting undocumented workers. So these are some of the guiding principles that have been adopted by the IMC. And then on the next slide, it's really the legislative framework that you are familiar with, the Immigration Act, the Refugees Act, and the Border Management Authority. And these, we believe, are the regulatory pathway that ensures that anyone who comes into our country adheres to the conditions of entry, and those that want to reside apply for the appropriate visas, and then, of course, the BMA in terms of management of the borders, and those that depart orderly. And then, of course, we do have a number of case laws with regards to the right of foreign nationals that we're not going to repeat. So that's just an indication in terms of that. And then if you look at the next slide, it's really the issues that we've already raised with regards to concerns that have been raised by communities, particularly the perceptions with regards to the competition for scarce resources, economic hardships, unemployment, and then, of course, issues related to service deliveries and heightened tensions. And we're of the view that communication through GCIS must reduce misinformation, but also ensure that we enhance social cohesion. And then we also reflect on the fact that irregular migration affects the state authority and national security, and that our response at all times must be lawful, coordinated, and credible. And then we also speak to the issues that I've spoken to around regional dimensions, that if we do not address as a region issues related to poverty, instability, and the limited opportunities in the countries of origin, but we also acknowledge that as a country, we have business and economic links, given the number of South African companies that operate on the continent, whether it's in the telecommunications sector, whether it's in the construction, whether it's our own state entities, and then, of course, in the banking industry as well. And our view is that solutions require regional cooperation alongside domestic enforcement. And then I've already spoken about activities that will not be allowed. If we move to the next slide, then indicates the engagements that we have had as the IMC on migration. I think by now they're up to 31. There were about 31 stakeholder engagements, including a number of clusters, and then these have been taking place between the 25th of May right up to last week on Thursday, but they also reflect a whole of government approach in addressing this matter. So the IMC has had quite extensive engagements, including with political parties, interest groups, whether it's March on March and Operation Dudula and others. We've also had engagements with various provinces, local government, Chapter 9 institutions and 10 institutions, and Limpopo, provincial government, metro mayors. We've had a number of media briefings, including others with SADC media houses, including with the Foreign Correspondents Association. But of course, we have been on a daily basis ensuring that there's public messaging on migration approach through the daily speaking notes. And then, of course, there were also the oversight visits that have been performed to Lindela Holding Facility by the IMC, and of course, by yourselves to the temporary repatriation facility, including by the Limpopo Legislature, the Committee on Public Administration. And then, of course, with regards to traditional faith and social partners, we've had faith-based organizations, traditional and Khoisan leaders engaged, Zulu Royal House engagements, labor, business, and private security, including the taxi industry, the World Council of Churches, the Fellowship of Christian Council of Southern Africa last week. And then, of course, at a regional level, the issues that I've raised that have been led by the Minister of DERCO. DERCO has had engagements with a number of embassies, including DRC, Tanzania, Ghana, the SADC IMC, and then, of course, the Pan-African Parliament also engaged. So I'm going to move at a faster pace on the next slides, because these are slides that you are familiar with on the temporary repatriation facility. Just by way of background, you will recall that people then started assembling towards the end of June at Sherwood, but this had already started in Harding, at the bottom of that slide. But there were some utterances that had been made. For example, in May 2026, the mayor of this municipality in Escort, Nkosi Langel Balele, had given an ultimatum to foreign nationals to leave within a period of 21 days. And then, of course, people started leaving the area. And then there was also this High Court intervention where 38 foreign shop owners had filed an urgent interdict because they claimed that they were being harassed. And then, of course, following that, a number of anti-foreigner marches took place in some provinces, particularly in KZN and GP, and consequently, a number of missions then announced that they were going to repatriate their nationals. First, it was Malawi, Nigeria, Ghana, Zimbabwe, and then, of course, Mozambique, based on activities that happened in the Western Cape, and then others then followed, including Kenya and the DRC. And then on the 6th, if you look at the timeline at the top, Malawian nationals started assembling in Sherwood Park, which is a very small facility, and others in Bredasdorp in the Western Cape. By the end of June, this situation had become untenable in terms of the numbers, but also the humanitarian emergency that had arisen. These sites, I must indicate, were not officially declared as government sites, but were managed by various NGOs, business communities, while government provided, of course, verification of documentation to either facilitate deportation or repatriation. Now, as a consequence of that, government had to consider the two options that were available. One is that we'll continue to do the deportation, which is the lawful process by which we expel a non-citizen from the country informed by Section 34 of the Immigration Act. And of course, under normal circumstances, Chairperson and honorable members, the responsibility of the host country, which in this case will be South Africa, involves us doing the verification and issuing the orders to leave. On the other hand, in terms of repatriation, this is a voluntary act of returning a person to their country of origin. And of course, here we are abiding in terms of the UN Convention of 1951 and the protocol of 1967. So this exercise, Honorable Chair and members, is voluntary, and ordinarily requesting members or countries bear the primary responsibility for transportation costs and the management of logistics in this regard. However, there are circumstances that arise where the requesting country does not have the financial, and of course, we then offer the humanitarian assistance, which is handled on a case-by-case basis. So we therefore had to commence with the repatriation process, and I will share a slide later on where the dedicated court in KZN tried to deport as many people as possible, but there was a time where the numbers were just far, far high than the process could handle. So we then started this responsibility around the 14th, and this is what the IMC directed us to set up. Minister has already spoken to this, the Temporary Repatriation Processing Center in Musina, which was approved by the Interministerial Committee, and we are remaining grateful to the Department of Public Works and Infrastructure, and of course the Limpopo provincial government that really assisted us to set up this center within that short period. So the main aim was to ensure that we timely repatriate and ensure the deportation in line with the legislative prescripts and timeframes. And you will note that it was after the closure of those other centers, eThekwini and Umsunduzi, and eThekwini, it was at the drive-in, which were closed on the 30th of June. All Malawian nationals that are assembled were then transferred to the temporary repatriation processing center, including those that were at the Musina Refugee Reception Center and the showgrounds. We then had to work with municipalities. Minister has already indicated eThekwini and City of Cape Town. and of course the various embassies and law enforcement agencies and other NGOs to provide transport services through the temporary repatriation center for those nationals that were keen to leave. But in the main, of course, it would have been Malawi nationals. So on the next slide, it's really the capacity that we were requested to provide, 20,000. That's what the IMC had directed. You will note that the occupation at some point was around 1,005, but since then it's declined. And then we had to work with all these stakeholders that I've listed, Limpopo provincial government that did the site clearance through Public Works. And then, of course, Public Works at a national level that was responsible for erecting the marquees, ablution facilities, and all the activities that the members of this committee saw. The local municipality, Musina, that had to make sure that all the food parcels that were being provided complied with the health provisions. And then, of course, the driving this work in terms of law enforcement has been net joints and, of course, the prof joints in Limpopo. And then, of course, the role of Home Affairs was to ensure that we ensure that there's provision of the documentation, the verification, including the fingerprints capturing, and of course, the issuing of the body-ready receipt. At the bottom, it's really the other stakeholders, embassies of Malawi that provided the collective passport, given the fact that the majority of these foreign nationals did not have any documentation. And then the Embassy of Zimbabwe provided what is known as a certificate of repatriation. And then, of course, SAPS to make sure that everyone who was repatriated goes through that verification exercise through the IJS system. And then, of course, provision of buses for escort, and then health ran that 24-hour clinic, and including health inspectors and emergency services. A number of NGOs that we really must appreciate provided services there. The Al-Imdad Foundation, Africa Muslim Agency, Musina Reform, Mahlasedi, Gift of the Givers, provision of meals, water, pampers, formula milk, sanitary ware, through that established kitchen that you went through. And then, of course, MTN and Vodacom for ensuring that the temporary towers for connectivity are established, but also provision of funding through the Gift of the Givers to the tune of 15 million through MTN. And then, of course, our partners that ensured that the activities that we indicated we were going to do, such as repatriation, was being done voluntarily with the International Organization on Migration, with the UNHCR, with UNICEF, so that they are able to observe the humane treatment of foreign nationals and the welfare of the children. And then, of course, SNDF that was providing on a daily basis clean water that was purified at the base, and then social development with regards to the social psychological services. It's important that we note the support that we received from these entities. The next slide then deals with the identification of the site location. Public Works had identified on the next slide, slide 16, this portion of land which belongs to Public Works, which previously had been used as part of the Agriculture Research Council, or the ARC. And we are told that's where they were doing research on this Bonesmara by Professor Bonesma. And then, of course, that's just an illustration of that portion of land and the hectares, which was, we were told that Public Works then had to find for us to utilize. So you'll note on slide number 17, the conceptual plan that we presented to the IMC, which was approved on the left, and what we actually ended up with on the right, based on the numbers that we were anticipating. So that site has since then been subsequently reduced in line with the current numbers that we currently are processing. So I'm not going to speak to the next slide because members of this committee were taken through this processing center. So I'll now move to the stats on the deportations. that the minister reflected on. So to date, by close of business on the 6th of August, we're able to process 82,875. Note, there are those that were repatriated, there are those that are coming through the deputation, and you'll note that the diagram only starts on the 30th. We do have figures from the 14th of June. We just thought let's highlight the peak period, and the peak was when we received at least or processed 4,850. You will note that that's really around the 4th and 5th when we received majority of foreign nationals from the Musina showgrounds, and then the lowest we processed was around 189, and you can see the numbers keep going down now, and the minister just indicated the latest number even lower than that 189. 3 nationalities in the main, repatriated and deported. You will note that for Malawi, the color scheme that we're using is green, the dominant group, and then Zimbabwe, orange, and then Mozambique, really flat. So these are the numbers in terms of what we've been able to process as of close of business, the 6th of August. And then on the next slide, and you must also note, honorable members, that because there were a number of processing sites, for example, outside the Malawi High Commission in Sentin. So once people were then processed, they'll then proceed straight to the port of entry, in this case, a Byte Bridge, and therefore will not be taken through the processing center. So in certain instances, you'll note the BMA would have higher numbers because those will not be counted at the processing center. And similarly, those that will be coming from City of Cape Town, some of them proceeded because we had officials that were working from there, and similarly in Pietermaritzburg. So you also requested, Honorable Chair, the details in terms of deportations through Lindela for the previous financial year and where we are. In the previous financial year, we're sitting at 44,607, and then we look at what we've been able to deport from April 20 up to the 28th of July, 16,078. Obviously, the numbers would have been higher. We just extracted data based on what had been the request at the time. At the bottom, we highlight the top 5 nationalities in terms of volume. You'll note Malawi in green comprises the majority. And in the previous financial year, there were the majority. In the current financial year, again, the majority, followed by Zimbabwe at 13,479, and in the current at 4,095, Mozambique 12,354 in the previous financial year, and currently sitting at 4,034. And then, of course, followed by Lesotho 3,495 in the previous financial year. We're currently sitting at 931. Obviously, the numbers are changing on a daily basis because this work is currently done on a daily basis. And then Tanzania. And then, of course, on the right, it's just a split of the total deportations per percentage. And therefore, it highlights the representation in terms of the color scheme at the bottom, green for Malawi, and the lighter green for Lesotho, orange for Zimbabwe, brown for Tanzania, Mozambique, blue, and then I think the committee also asked about other nationalities, and those we then provide for on the next slide, on slide number 22. The committee also indicated that we must share this information. You will note that those are the other nationalities that are being deported through Lindela, including those from Vietnam, Algeria, Bolivia, Brazil, UK, Thailand, Slovakia, Paraguay, Liberia, Lebanon, Jordan, Hungary. And then, of course, for this financial year, you will note as well, the figures also include other nationalities from Somalia, Thailand, Bangladesh, Benin, across Botswana, Cameroon, Germany, Paraguay, Rwanda, and the United Kingdom. And then, of course, there's work that we've done with regards to the courts on the next slide. The work that the Department of Justice has been able to do. These are cases that were finalized through the dedicated immigration courts that are currently there. 28,737, and of course, KZN is second from Gauteng, sitting at 4,973. Gauteng had the most cases, so high volume. And the other provinces, their share is really 54%. Western Cape, 3,334. Eastern Cape, 2,019. And then, of course, you'll note Mpumalanga and Northern Cape has the lowest. So that's the share in terms of what those courts have been able to do. On the next slide, we also reflect, if you look at the same period between the 1st of June and the 9th of July, when this matter started getting attention, the Chief Magistrate in eThekwini established at least 7 dedicated courts. One was virtual with a virtual link to Sherwood, and the other 6 operated from Durban Central. You'll note that during that period, they were able to finalize 2,173 cases, which means they were processing quite a lot of cases. Now, this is quite important in the context of what the President announced on the 7th of June, that we will be establishing these dedicated courts. At OR Tambo, we're likely going to end up with a full court. AXA has provided us with space, and the architects are busy with plans for that area. And then in Lindela, we're busy expanding, or we're intending to expand that court from 1 to 2 dedicated courtrooms, so that we're able to process faster and quicker. And then the other areas are also illustrated in terms of what they were able to process. But we've been able, through this exercise, we've also been able to pick up where courts are not processing faster, and those interventions are being made by the DDG responsible for courts at the Department of Justice and Constitutional Development. And then the committee also asked us to speak to the declaration of undesirability. On slide 26, we provide information on travelers that were declared undesirable for the previous financial year, 63,090. And then for this financial year, we're still sitting at 20,340. And then, of course, the measures to address these cases of overstaying, you will note that there's a 1-year ban for overstay of 30 days, and then 2 to 5-year ban for longer. And then, of course, issues relating to special judicial processing with regards to Section 34, and then Section 30 in terms of declaration of undesirability that are made. So that's what we wish to report on. And then as I move towards closure, it's really the financial implications. Chairperson, I need to indicate that this is an unfunded mandate. As the Department of Home Affairs and other departments that have been involved in this matter, we have not budgeted for this. As you know, that repatriations are not provided for in terms of our own legislative framework. So to date, this is what we've spent, 292 million for these 7 items. And of course, the largest component went to the buses that were procured. Of course, the city of eThekwini did provide buses in terms of transport to the repatriation center. We've since refunded the city of eThekwini. We're grateful for the support that we received. City of Cape Town, similarly, 3 million. And we are grateful for the support that we received from these 2 cities. And then, of course, the biggest was from the Department of Home Affairs. Then we also need to ensure that the Public Works Department for the establishment and the operations of the temporary repatriation center. There's 48 million to date. You'll recall that we've started to downscale the operations. And then, of course, those that we needed to provide flights from eThekwini to come and assist. And then, of course, the overtime, well, this is what we have as an estimate, because the colleagues, when we started, were operating until quite late, given the numbers. Now, the PFMA Act provides for conditions for allocation of funds through adjustments to budgets to finance for unforeseen, because this is unforeseen expenditure and unavoidable expenditure in terms of Treasury Regulation 6.6. But we also received, Chairperson and Minister, a letter that we received to finalize from the Budget Coordination Office on the 23rd of July, that we needed to submit a cap memo on this unforeseen and unavoidable expenditure arising from the repatriation. This is something that we anticipate the Minister's Budget Committee to consider. The deadline was the 7th. We've complied with that deadline. And of course, if you look at the top, this is what we had been allocated by CARA at the time. We did not anticipate the huge volumes. So CARA had allocated us 60 million. And of course, we have also written to the government of Malawi, and of course the embassies of Nigeria and Ethiopia, requesting reimbursements of this cost through the Department of DERCO, and we anticipating responses from those governments. So if you look at the financial implications with regards to Lindela, the current capacity, it's 4,000. It's been hovering around 1,500, and then it's times around 2,000. This in the middle, we provide the daily rate for the food rations that are provided. Our budget for Lindela, for the deportations for this financial year, is currently 57 million. Obviously, with the exercise that we've been undertaking would have gone beyond that budget, which therefore required us to write to the Minister of Finance asking for reprioritization of certain budget line items. So you can note at the bottom the graphic illustration of the costs per financial year as requested by the committee for the 2023-24 financial year. You will note that the deportations are actually more than what we would have allocated. 24-25 years, same, peaking at 101 million. If you look at 25 to 26, sitting at around 73. So it might be because the majority of the deportations are to our neighboring countries. Where the costs are more are those where we have to pay for flights. And then, of course, for the current financial year, that's as of latest June. Of course, this will need to be adjusted, including the current figures. So the last slide, then, it's a recommendation for the committee to note the work that has been done on the repatriation and deportation of foreign nationals, and to thank the committee for the oversight. Thank you very much, Minister and Chairperson and honorable members.
Thank you very much, DG, for the detailed report. Can I now invite the Commissioner, Mashapata?
No, thank you very much, Chair, as well as the committee members. Just a second as I share the presentation, and we should be able to be running as we speak. Chair, if you can confirm that the presentation is fairly visible on screen. No. Just a second, Chair. Chair, if you can confirm the presentation on screen.
Yes, proceed, Commissioner.
That's great. Thank you very much, Chair, committee members, Minister, DG, and all the committee members. The presentation by the BMA is fairly short on the basis that most of the broader issues are being covered by the DG's presentation. So on that basis, we just wanted to amplify this slide just to indicate that we will be talking on one aspect, which is the aspect on what we call Workstream 2, that deals with the issues of secure borders for ensuring that we put in technologies to make sure that we do the work that is meant to be done. And that is arising from the address by the President in terms of the 7th of June. So on that basis, we just want to start by bringing some bit of context to the committee members. And this particular context becomes very much critical, particularly because there is already a mechanism that is already in existence in as far as border management is concerned. You will remember that the work that is being done by the Border Management Authority is being reported to at the Border Technical Committee of Directors General, as well as head of entities. And then after that, it then goes to the Interministerial Consultative Committee on Border Management, which is consisting of 10 ministers, being chaired by the Minister of Home Affairs. But for this particular task, based on the articulation by the President, then the model then gets to be a bit broader and gets to be a bit bigger. And that is why now the ultimate submission then drifts towards the Interministerial Committee on Migration that the DG had spoken about. So on that basis, for us to be able to do the work and be able to feed into the bigger picture, we just want to indicate that through the subcommittee of the Border Technical Committee, that is called the Border Security and Operational Committee, which is the committee that drives the work in the front end. From a strategic command perspective, that particular committee had to then integrate with the nut joints from a command structure perspective for the purposes of doing this particular work as it stands. So on that particular basis, we had to then start doing this work through a full resource integration, through which we then had to account for the work that is being done in the border environment, but in a more broader context, wherein we reflect on the work that is being done even by the police, both in and out of the ecosystem, but also the work that is done by the Defense Force, and ultimately the work that is being done by our colleagues in the revenue environment, together with the work that is being done by the Cross-Border Road Transport Agency. Additional to that, the same structure of what we call a BSOC is also dealing with the work in terms of intelligence operations. So in this particular instance, there has to be guiding the work for the purposes of implementing this particular work stream 2. And for that to be ultimately fulfilled, we also had to be deploying our standard operating procedures in an integrated manner and make sure that the work that is being focused in terms of the port of entry, we are also able to account in terms of the work ultimately on the vulnerable segments, but at the same time ensure that we are able to do a very direct interface with the work that is being done by the by the Defense Force. So on this particular context, we just want to indicate here that to be able to respond to the presidential instruction on the basis of the 7th of June, but also being able to feed into the Interministerial Committee on Migration led by Minister Kubai, we ultimately had to allow the nut joint itself to ultimately create a work stream within their own environment as the nut joints, but of course, as the Border Management Authority, we had to then lead that particular work stream to make sure that we are able to then do the work in that particular environment. At a local environment, we had to use our existing port management committees to make sure that we are able to provide all the technical data that is required for reporting purposes and make sure that we are able to feed back into the entire mechanism. And that on its own had been enabling us to do joint planning in terms of the implementation of the work, both in and out of the ecosystem to make sure that we are fully aligned. Now, the next slides are just demonstrating some of the technical responsibilities that we are actually doing in terms of the border management, ecosystem feeding into the work that has to be done, and ultimately the work stream 2 as articulated by the president. You will remember that the president has spoken about the deploying of the technologies around the border environment, something that we've been doing under normal circumstances from a border management authority perspective. But in this instance, we had to be very much upfront in providing some of the updates in terms of the IMC, in terms of the work that they do. You will realize that here in terms of item number 1, the minister has already spoken about the launch that is going to be happening tomorrow in terms of the electronic traveler authorization, but also the enhanced movement control system 2.0. So here we are just demonstrating that in feeding into the work of that work stream 2, we will definitely be having this launch tomorrow, as the minister had said, but more critically, we need to be able to do the rollout of the EMCS 2.0, in particular across the various ecosystems in terms of the land, sea, as well as airports, and make sure that we are able to do the work. That is why there we are just demonstrating some of the technical work that has been done by the team to demonstrate the cost in terms of the rollout of EMCS 2.0. You will see there that there's something like around 250 million. And you will note that these are just the additions of trying to bring the update into the slides on the basis that the original ones were distributed some few weeks ago. So here we are basically demonstrating that there is also a lot of work that we need to be doing to, improve the networks across the ports to be able to make sure that we are able to have these technologies roll out across the various ports. But more critically, there is also a need for procuring of the cameras that are supposed to be deployed across the ports for the purposes of facial recognition. And there we are also trying to bring some bit of costs that are associated with this. So this will then be given more attention immediately after the launch by the president, because the rollout of EMCS will then become one of the most critical part. But the second part around the same instruction from the president is the whole issue of full activation of our operational command center, as well as the National Border Targeting Center. In here is us having to do the work to make sure that we are able to stream the activities that are happening at the front end, which means at the ports of entry into head office. And we should be able to stream the activities of the drones, as well as the activities of the body-worn cameras and all of those. And that then becomes very much critical. All of these are the activities that are unfolding in view of implementing that work stream instruction as being expected. We also just want to update around the issues of the customs online traveler declaration, which is something that is fairly new. On the 1st of July, it was implemented by our colleagues from SARS, and this is now starting to want people to do their declaration, especially when they move even vehicles interjurisdictionally, so that we can then take stock of all of the vehicles that are foreign registered entering our jurisdiction across our land ports. Now, the second part is the part that has been spoken to. I suppose the DG also had some bit of touch around this particular aspect. And I suppose this is one of the activities that has been fairly embedded in the white paper itself. And that is the relocating of the refugee reception centers to the ports of entry, just to indicate that as part of doing border management differently, this work is actually underway. The team from the Department of Home Affairs has visited various ports. I know that they've been in Beitbridge, they've been in Libombo, just to engage on these particular aspects of making sure that the refugee reception centers are brought at the port. Because you will remember the problem statement we are trying to resolve. Currently, if somebody arrives at the port and they want to apply for asylum in the country, we give them a Section 23 permit as provided for by the Immigration Act, which gives them 5 days to go to a refugee reception center. And we know the problem. The problem has been that when those people enter the country, some of them don't even go to the refugee reception center, but they literally just walk into the country until that particular permit expires. And that has always been very much problematic. Hence, now we need to deal with everything at the port, so that once there is a rejection, that particular individual must be able to return back or must not be allowed to enter the country. So this work is fairly underway, and the team is doing some work to make sure that this is effectively implemented. Now, in terms of the third, more critical work, is about what you will call the integrated work broadly around the issues of strengthening border management. And in here, we are talking about a lot of activities that are part of what is embedded in the work that we do. But we just want to say that the multidisciplinary border law enforcement operations becomes very much critical, particularly to make sure that even as we do border management work in port, but we need to be able to make sure that other stakeholders assist us in having the static roadblocks on the corridors. You will remember here, for example, in terms of the N1 to Beitbridge, we talk about a static roadblock at Baobab Toll Gate, which is 30 kilometers from Beitbridge itself. And that becomes very much critical because it enables us to be able to pick up individuals that might have compromised the system, either out of port or by any other means. And we're able to then catch them at that point, and we are able to make sure that they are processed back into their countries of origin. That is one of the most fundamental issues. And I think the chair and the committee members will note that since we implemented this, particularly in terms of our North Corridor, there has been less incidences where buses are being found inside the country with people without documentation. We also talk about just broader issues of intensified inspections and intensified screenings that we have to do, particularly within the environment, at the port of entry in particular. And here we are talking about something that has been more of a relaxed activity over time, wherein the implementation of the provisions of immigration protocols and requirements has not been that strict and that intensified, particularly in our land ports. That has been fairly intensified at our airports, but at the land ports, it has not been fully intensified. And that is why now we have started to intensify that. And you will be aware that in terms of the subsequent slide, we will start to indicate some of the, I would say, returns or denials of entry that are starting to be implemented. And we have actually even indicated that as we intensify this work, there is going to be a possible political noise that will ultimately emerge. But in this particular instance, there is readiness to be able to deal with those particular aspects. Now, in terms of the strengthening of border security, this is one of the key issues, honorable members, particularly when we talk about the activities that happen outside port. One thing that we have to be very much explicit about to the Interministerial Committee was the fact that as we do the deportation, the biggest threat is always the possibility for people returning into the country outside port, meaning through the borderline. So on that basis, there has been a collective work to make sure that we strengthen this particular work, particularly in view of the challenges of the Border Management Authority from a capacity perspective, especially on human resources. So on this instance, we have to then ensure at the NAJOINS level to make sure that there is additional deployments that we have to be assisted through by members of the SAPS. And that is why you will see there that we are talking about around 63 of SAPS members that has been deployed into the Northern Cape side, particularly to make sure that when people realizes that other areas are more tighter, they are likely to then drift into the other vulnerable areas. And on that basis, we had to start making sure that those deployments are actually activated. So if you look at the deployments of the Defense Force there, you will realize that we have also spread the ultimate deployment of the Defense Force, various contingents has been deployed in various vulnerable areas. And part of this work through Operation Corona is to assist the Border Management Authority in terms of what we'll call border law enforcement, but mainly to make sure that people do not walk into the country through the vulnerable segments of the borderline. And these are all of it put together, the strengthened work that is being done in a multidisciplinary context to make sure that we intensify the border management ecosystem. Now, the latter part of the brief is now starting to talk about broader issues that are instructed of us in terms of Section 5, subsection C of the Border Management Authority Act, and that is to intensify collaboration with various stakeholders around the border ecosystem. Here we talk about communities themselves, but also farmers themselves. And this is the work that we've been doing all this while. But now with this activity now, we had to intensify it. And that is why now we have border security forums that we are establishing across our port environment, whether in the North Corridor around your Bait Bridge area, whether in the East Corridor around Lebombo area, but mainly to make sure that we also interface with the local safety forums that are mainly linked to the nearest police stations there, but mainly to be able to ensure that there is a full deployment of the abilities of the various stakeholders in terms of ensuring that we're able to share information, particularly in those instances where undocumented individuals are either found even in those farming areas, doing some bit of work and all of those. So all of this work is being done within this broader context to make sure that we are able to deal with the issues that we are supposed to be dealing. Now, on this particular part, this is the last slide talking about the areas of work that we are actually amplifying in this particular instance. You will realize there that in terms of item 5, we have to be handling the deportations and repatriation. As the DG had indicated, the department will do the work in the country, whether at Lindela itself or even at the Musina Temporary Repatriation Center, but all of them in any way they then get to the port. And obviously from a border management perspective, we have to then do the work. And of course, there are those that will then come directly to the port. Hence, the next slide, when we talk about the statistics, you'll start to see that the BMA statistics are more higher compared to those that the DG has presented. And I think the DG did indicate the reason in as far as that part is concerned. So in terms of item number 5, the next slide will start to give some bit of statistical view in as far as the work done in as far as that activity is concerned. If you look at slide, I would say activity number 6, this is the whole issue of ensuring that there is some element of a physical barrier that has to be brought into the ecosystem to make sure that we close some of these vulnerable areas. And I can confirm in this instance that there is a subcommittee that the INC has created, led by the Minister of Defense, to make sure that there is some bit of work in as far as that part is concerned. I suppose the issue will be more pronounced at the ministerial level, especially after the cabinet would have then engaged on this particular issue, and ultimately the chair of the IMC, as well as the Minister of Defense and the Minister of Home Affairs, will be able to do clear pronouncements in as far as this part is concerned. However, from where we sit at the technical level, we have done all the technical work that is required in terms of identifying the vulnerable areas across the borderline, but also indicate the kind of figures that will be required for that kind of work to be done, and the rest of the other issues are being handled at the political level. Then the last issue there is about the entire issue broadly of the modernization of the entire space. And you will see the phases there that are being articulated in terms of addressing that particular part. Now, as I move towards conclusion, let's also look at the issues of the figures. And I think the DG had fairly given some of the figures there, but the figures as the DG had articulated them are more in the context of the department, but also those figures then are part of the figures here, but they are figures that are not part of this because they are actually more additional. So we just want to look yourselves to look at the bottom part first, just to look at the repatriation that has been done. So we are now talking about 89,936 repatriations that has been done. And this is as per the 7th of August. This is last week, Thursday, and this is where we are sitting. You will realize there that if you look at the figures out of that 89,000, over 54,000 of those are Malawians, and mainly they have been processed at Bait Bridge corridor. And on that basis, they were fairly processed out of that particular space. The second highest nationality has always been the Zimbabweans. We have around 27,000 of those that actually exited once again at Bait Bridge, a port of entry. And of course, the third highest is the Mozambicans. You can see that there hasn't been much of the Mozambicans that had been part of this particular repatriation. We talk about just around 2,200, as you can see them there. And then over and above these ones that we have done on land, there has been some few that we have actually done at OR Tambo International Airport. You will see we have around 1,000 or so Nigerians that were done at OR Tambo, around 958 that were done again at OR Tambo being the Kenyans, and we have about 358, 958 being the Ghanaians and around 358 being the Kenyans. And we also have around 800 Ugandans that were also processed in that particular context. So basically, this is now the essence. And at the bottom of that particular quadrant there, we just demonstrate the actual number of those that we received from the Musina Temporary Repatriation Center, which is around 77,000. And that is the number that is coming from DHA. And out of that, we had to get those numbers aggregated and ultimately be able to deal with the issues. In conclusion, we just want to indicate that from April 1st until the 31st of July, as we have been doing all of this work, as well as all of the repatriation been unfolding, there have still been individuals that has been attempting to enter the country illegally. And that is why there we are just indicating that we've been able to intercept over 4,229 individuals that did not have documents, that were once again attempting to enter the country illegally. And the majority of this being intercepted in our North Corridor with Mozambique, with Zimbabwe, and then followed by Lesotho and also with Mozambique. But at the same time, we have also been able to implement around 318 joint operations. We describe them as multidisciplinary, mainly because some of them were happening outside the port environment. This is the deployment that we do on the corridors to make sure that we have static roadblocks to be able to intercept individuals that might have been able to flout the system either on the borderline or otherwise. And that is basically the operations that led to this 4,000 plus individuals. We also had around 760 individuals that got arrested. In this instance, there has been a targeted work to arrest what we call facilitators. These are individuals that try to, in a way, to assist people to enter the country illegally. And that has actually been the essence. Despite all the other numbers that we've spoken to, there has been just below 10,000 deportations that we've also been able to process just within the border law enforcement area on that particular basis. Now, if you look on the right hand, on the top right there, we talk about 12,100 individuals that were refused entry. So this is the issue that I've demonstrated earlier, Honorable Chair and committee members, and say that we have started being strict, particularly in terms of the land ports. If an individual is not able to give us a clear address as to where they are going into South Africa, even if they are qualifying to be getting the days, if somebody is not able to demonstrate that they have money to sustain themselves as they enter into South Africa, if they are also not able to indicate clearly the purpose of their visit, we are now, even in terms of the land port, been more strict, and that is why there's over 12,000 plus individuals that has been refused entry just in a 3-month period. And that is basically the essence. Those that has been declared undesirable, they are sitting at over 5,000, and these are obviously the repeat offenders as well as those that has been found to have overstayed their visas in the country, and we had to make sure that they are put on the system so that they do not enter the country, at least as the DG had said, 5 years if it's 2 years plus, or actually, if it is more days, it will be 5 years undesirability, or 1 year if it is not a lot of days. So that is fairly the brief that we had brought through to the committee. And I suppose the issue around the cost, as the DG has given a very more comprehensive issues on the cost. From a border management authority perspective, the only cost that we had was just the deployment of additional officials at Bait Bridge, especially when we were dealing with a lot of buses that were coming from the repatriation center. Some of them were even coming directly from Cape Town, Durban, and other places before the center was there. So we had to bring in additional resources there. And on that basis, we then have around 11.8 million. That was an additional cost outside the budgeting. And as the DG had said, we had to also put together a CAP memo that we submitted to the to the cabinet process or to the budgetary process for them to look at refunding that particular money into the environment. So that is the only cost in terms of the BMA. The rest of the other areas like OR Tambo, we didn't have to bring additional resources because the pressure did not warrant as such. And the same with Libombo, we did not necessarily do much of that. The most of the additional people were at Bait Bridge because the buses were really coming in numbers. So that is basically the cost implications in terms of this particular work from a border management authority perspective. Thank you very much, Chair, committee members, and the Minister.
Thank you very much, DG and Commissioner, for detailed presentation. I know that we interacted with the presentation, but also during our oversight on both areas of the repatriation center and also the BMA facilities, with an opportunity to interact with the ground forces. So the report does reflect some of the issues that our members have interacted with. Members, I'm inviting you to comment on the areas that have been raised. I'll start with Honorable Machi.
Thank you very much, Chairperson. Firstly, I would like to thank such a comprehensive presentation. We've got to thank the presenters for a well-planned and prepared report. I've got some questions, Chairperson. Mine's just in relation or based on repatriation and deportation progress. Seeing that Gauteng accounts for nearly half of all finalized unlawful immigration cases, are there any specific measures in place to encourage finalization in other provinces? Second one, following the recent humanitarian crisis of Malawians nationals gathering at Sherwood Park, are there any contingency plans underway in case this issue arises again? Last but one, how long is the temporary repatriation process center expected to remain operational? Lastly, in light of the recent closing of the eThekwini and Msunduzi repatriation center, is there a possibility of making a TRPC permanent to account for the possible overflow of migrants? Thank you.
Thank you, Honorable Ross.
Thank you, Chair, and to all the presenters for the comprehensive presentations. Chair, firstly, to congratulate the department and the Minister and the Minister of Public Works for setting up such a repatriation facility in just 4 days. It's quite an incredible achievement. And we also welcome, after the unprecedented progress on immigration enforcement since 2014 by Minister Schreiber, so 600,000 deportations, record numbers of internal enforcement operations, drones and body cams at borders, that had such a big impact. It's good to see the establishment of the Interministerial Committee to drive coordination and build on that progress. And we also saw, Chair, the Zimbabwe side, and what is possible when we address the underinvestment in borders and immigration management, what is possible. Dr. Mesiapato, first of all, it's good to hear that immigration officials are starting to ask for addresses. Where are persons going to stay when they come into the country? Do they have enough money to sustain them, etc.? This is something that many countries do this. And 12,000, you say, have been refused entry. I just want to understand on what basis are these decisions made fairly and objectively? Is there an SOP, or is it completely up to the discretion of the immigration officer? And then we look at the estimated cost for the mass repatriation and the foreign, or the deportation of the foreign nationals. Well, let's just call it repatriation and be clear about that. So it's a rather large amount. and we were assured that the repatriation was being paid for by the sending countries, mainly Malawi. I just want to understand, have these expenses been recuperated, and if not, what is the progress in that regard? Then, as the chair has alluded to, when we were on the border, we received accounts of the limited number of persons that were there, saying that sometimes they are confronted with 30 groups of 30 persons with automatic weapons trying to smuggle goods across the border. And often cases they are outnumbered. And Parliament noted a funding shortfall exceeding 2.2 billion for the BMA due to the reluctance from legacy departments such as SAPS to transfer funds and personnel. And so my question is, as I always ask, what is the executive interventions that are underway to finalize these Section 97 transfers? Have they completely stalled, or is there any progress in that regard? Then, with the total of 89,136 persons repatriated, there's a legitimate public concern that these undocumented individuals will simply cross our porous borders and return. So how is the Border Management Authority effectively utilizing its counter-return plan, the daily satellite surveillance images provided by SANSA, and the deployment of drones and ground sensors to guarantee that deported or repatriated individuals placed on the visa stop list are permanently intercepted? And then finally, I think a very important point is, it's noted that between April and June, a total of 28,736 illegal immigrant cases were successfully finalized across the country, with Gauteng finalizing 13,312 cases alone. And in this committee, Chair, we spoke of how specialized courts can be game-changing in terms of processing illegal immigration. So I'd like to understand, how as the operational driver of dedicated courts, such as the 6 dedicated courts in Durban Central, contributed to this rapid processing, or the rapid processing that we saw? And what is the status of expanding the successful model to OR Tambo and to the Lindela Court? Thank you, Chair.
Thank you, Honorable Rose. Honorable Mtolo.
Thank you, Chairperson. Chairperson, I have a question here at repatriation and deportation. I welcome the effort to strengthen the system. However, I believe we need to look beyond enforcement alone. What measures are being taken to engage sending countries about the push factors that contribute to illegal immigration? So we must also ensure that enforcement is balanced with the protection of human rights. How does the department ensure that this balance is maintained during repatriation and deportations? And there have also been concerned that repatriation and deportation may unfairly target Black Africans. Can the department provide the committee with the demographics of persons who have been repatriated and deported? On the Border Management Authority, lastly, Chairperson, while deportation and repatriation may address illegal immigration in the short term, I believe we need a sustainable long-term approach. What is the long-term strategy for dealing with illegal immigration, including any possible policy intervention? I thank you, Chairperson.
Thank you, Honorable Mtolo. Honorable Bolman.
Thank you very much, Chair. Chair, I would like to also thank the presenters for such an in-depth presentation. It really, really goes to show how we have progressed in these meetings where there's very little comment or questions. And I think it is something that is commendable. I'd also like to concur with my colleague, Honourable Ruiz, on the success that was the Temporary Repatriation Centre. Living in Durban and knowing how down to the wire it was, moving these folk from the Durban drive-in to the Temporary Repatriation Centre in Musina. and essentially to safety before the March and March deadline. It was nothing short of remarkable. Yeah, it was quite tense down here. So I want to say thank you to everybody involved in that. Chair, I do have 4 questions. The first one is that there are reports that Malawians and other nationals or foreign nationals who were previously repatriated are re-entering South Africa on 30-day visitor visas. I'd like to understand what systems does Home Affairs have in place to ensure that these individuals leave the country when their authorized stay expires, and to identify those who overstay or use visitor statuses to remain or work unlawfully in South Africa. So effectively repeating the cycle. I think we all know that there are syndicates and systems that operate underground. It's the only way I can explain it. I mean, I even found out last week that foreign nationals have a courier service that they can send their passports out of the country to obtain visas if necessary, or even outdated passports where they can apply for passports outside of South Africa while they remain inside South Africa. I'm busy working on that now. The second question is, when a person who has previously been undocumented, deported, or repatriated applies to re-enter South Africa, is that immigration history automatically visible to officials at the port of entry? And what additional scrutiny is applied before admission is granted? So obviously we have systems where we are working on both the manual and the electronic, and I believe on Wednesday there's the further rollout that will be taking place. But in the interim, you know, are we still seeing a massive gap in the system that potentially could pose problems in years to come? I mean, from what I understand, in 2015, I think there was about 19,000 Malawians that left. And this time we've seen almost double that. So we've got to sort of close the loop there. The third question is the department considering a defined time-limited regularization process allowing undocumented foreign nationals to come forward voluntarily, their status is assessed, and either regularize their stay where legally entitled to do so, or deport the country, rather than remaining indefinitely outside the immigration system? And the last question, this is again in line with the various discussions we've had regarding the Metro Police, in this case, more specifically, the eThekwini Metro Police, working with Home Affairs immigration officers. It would appear that there seems to be a disconnect currently on the ground between Metro and the immigration guys. And as such, they're not working as cohesively as has previously been indicated, working in silos. I'd like to understand, because I also understand that the NPR will be made available in due course, but I mean, obviously, when is that due course? What is the timeline? How are we going to circumvent these issues where an operation, say for an example, is being run by Metro Police, but because of the very scant amount of immigration officers in KZN, they are unable to commit to working. So basically, Metro Police would do the hijacked building, and then what? So there still is a disconnect there. But yeah, essentially those are my 4 questions. Thank you very much, Chair.
Thank you very much, Honorable Bondman. Honorable Mudisimta.
Thank you very much, Chair. Let me also appreciate the presentations that have been provided. Chair, firstly, I will start with an issue that has already been raised with regard to the return, and it for me is to really get an indication from the department and the BMA if they have a counter return plan, as it has been indicated that those that have left the country would use that 30-day and would want to return back into the country. But with that, Chair, it's that those foreign nationals are taking an advantage on the weaknesses that we may have in our immigration laws or our systems. And with that taken into consideration that there are areas that have been identified that they are being exploited, what then is the plan of the department and the BMA in ensuring that they are able then to curb and deal with those issues, if indeed they have identified areas that are being exploited by these foreign nationals who enter our shores illegally? So, Chair, when we visited the Musina area, we received a presentation. Some of the questions that we asked were with regard to the demographics that were provided for us in the presentations, which in this instance also they indicated there on slide number 21, the top 5 nationalists that have been identified that are the ones that are living or are voluntarily leaving our country in volumes. And still, Chair, we are still not getting an indication that other than those African black Africans that have been identified from those top 5 countries, we're still not getting an indication if there are any other nationalists that are living through the systems of those deportations, the emergency deportations that we are currently embarking on. On slide 22, it then goes further to speak about deportations that are taking place through Lindela. The numbers that are shown there, because I think they are attempting to show us more other nationals or countries that are then being deported. It's still not a satisfactory number that you are seeing there, because the numbers are very low. If you compare to the black African countries and those of the Pakistan, the Bangladesh, you are having 9, you are having 10, you are having 6 here, you are having your Somalians and your Thailands 2 or 1, you are having your Germany 1, your Paraguay is 1. So does that then indicate that we are having an issue where these foreign nationals are still largely in our country and they are not living, whether they are illegally so, or whether they have proper and legal documentations, vis-a-vis the top 5 black African countries that have been identified? But I needed to say, Chair, that the numbers that have reflected in both those slides, really they are not satisfactory. Then, Chair, I will then move to a slide that speaks to the financial implications. An indication there of money that has been spent, the known amount of money that has been spent, which amounts to the 292 million, and the money that has been spent by the department in this emergency deportation of 203 million. I just want to find out, Chair, on where does this 203 million come from? Was there any additional funding that was received by the department from the Treasury for them to be able to deal with this process as an additional funding or cost? Or was the money taken from other targets in the department where this money was supposed to be spent on other areas? Just to get an indication of where this money is coming from, the 203 million that the department has spent on buses that were ferrying out foreign nationals. Also, the 60 million CARA, we would have been seen when we visited the border management during our oversight that indeed there is a serious need for funding. Yes, it's something that we've been overemphasizing in the previous meetings, but having gotten a site experience, particularly regarding the drones, the operations of the drones, the body cams and simple equipment as phones, what do you call those? whatever the phones that the BMA would have required to be able to have a communication from the soldiers who are, or from the board guards who are on the ground, and those that are in the bases. Those are equipments that are really missing. There would have been an equipment that also inspects or searches the trucks. We've seen that they operate on one battery, and when that battery dies, they then have to go and recharge the battery, and it means during that period of charging, there is no equipment that is being utilized to inspect or even search those trucks. So we would have realized last year that there's a great need for border management to be sufficiently funded. Now that there's been a 60 million that has been received from CARA, my interest is finding out that is there any additional funding, particularly during this period, that has been channeled towards the BMA for them to be able to acquire some of these equipment that they are needed urgently, or all this money has been spent on, the focus has been on the repatriations, but no investment has been made to ensure that at least somehow we find a way of funding the BMA. And lastly, Chair, is to say, looking at these amounts of monies that have been spent, it really raises a great concern, is that was it a great investment from ourselves as a department to ensure that we send off these illegal foreigners without getting any financial assistance from the countries where we are deporting these members? Or is there any agreement or a cooperation from these countries where the department will be able to recoup these resources that has been spent towards this process? Thank you, Chair.
Thank you very much, Honorable Modisimza. Honorable Ngubane.
Okay, all right. Thank you very much, Chair, as well. I think the nice thing to speak last is most of the questions have been asked by colleagues, but mainly, Chair, is to us to ask about that the reimbursement as well, to say the DPWP and eThekwini and Cape Town, they need to be reimbursed with that money that they forked out, and to ask as well the same question: what's the strategy? Are we cost recovery that we're doing on Nigeria, Ethiopia, and Malawian embassies? That's the first one which the colleagues have asked. And then the other questions, Chair, is on the BMA and the Home Affairs. What are these plans, long-term plans, of dealing with these glaring hot areas that probably people, when they speak about immigration issues, are pointing to try and say there's nothing that is being done? Areas like Johannesburg, inner city and greater Johannesburg, areas like Hillbrow, Yeoville, Foxburg and Kempton Park. In Durban, areas like Durban Central, Point Road, and in Cape Town, there's a high level of concentration in Central Belleville, as well as in Tshwane, in inner city and Sunnyside. To just ask the Home Affairs and the BMA that what is the plan? It's because those areas needs to be eradicated, because you found people there more that are illegal immigrant with all wrong papers, and some are the one that makes this exercise, that big exercise, that the repatriation and deportation exercise that was done on a rush of the due date of the 30, a mockery, when you now see these people still roaming around, and some are even refusing to leave because they say that no, it's because that probably we've lacked for so long, for the past 30 years, in taking these serious issues of immigration in deportation and repatriation. And then on the second presentation, Chair, is to ask the question of the SIU border fence recommendation that was revised from 6 to 12 months to immediate. That what has physically been installed since that revision, and what change has justified that, if there's been changed, as well as to request the BMA and to concentrate as well on that undocumented population, the recycling, people who goes out and come back, to say how can we then bar that and deem them as people that must never ever enter the country, since they keep on coming illegally. So I think that those were my few questions, Chairperson. Thank you very much.
Thank you very much, Honorable Ngubane. Honorable Matopa.
I'm covered, Chair. Thank you very much.
Thank you, Honorable Ngubane.
Thank you, Chair, and good morning, good afternoon to all of the colleagues. I'll also keep my video off because I don't have strength in bandwidth. I just have a couple of clarity-seeking questions, and I will speak to them in this particular fashion. Firstly, I think I want to, align myself with the previous colleagues, particularly Honorable Mudisemja and Honorable Bowman. I want us to perhaps try and be as honest as we are on oversight. And so let me start my questions in this particular fashion because this matter really has got to be gotten under control, colleagues. I've just traveled in the last week and a couple of days, and the emerging hatred for South Africans is really palpable in how people are responding to what is particularly happening in our country, for better or for worse. And so I want to ask this question. The first one is around, the commissioner spoke to, us being very deliberate now with regards to how we are dealing with the questions that need to be asked, particularly at the land, ports of entry on land. But I think all of the members who were on the oversight committee, the oversight visit to Beitbridge, we all saw one of the officials, what happened with that particular official who was processing a Zimbabwean national who was coming into the country and flippantly, just almost filled the form for this individual, even knowing where the individual was going and making the assumption that this individual or that the official knew what the individual was coming into the country to do. I would like to know what has happened to that particular official, if anything, because it was not only the committee that saw that, also the commissioner and other members of BMA saw what happened with that particular individual. I'd like to understand and know what has happened to that particular person. The second question, and the second perhaps the assertion I want to align myself with Honorable Bowman around is this a situation of the 30-day or 3-month re-entry that people keep going to their respective border posts, stamping, going back and then coming back again into the country. What does that tell us if it doesn't tell us that people are actually residing in South Africa and that they are working in South Africa? How effective are we with regards to these particular individuals? Because they're able to do it for many years on end. How are we really dealing with this particular matter? On Honorable Mudisemja's question around resources, I think it's very important for us to understand the plan. We understand that there's very limited resources. I mean, you have one drone at Beitbridge and one pilot. I mean, that is absolutely not sufficient in terms of how effective we need to be in this regard. What actually is the plan to ensure that we move from this under-resourcing of the Border Management Authority and the system overall? What is the actual plan? I would like to really just get a sense of that, because I think while there is a full appreciation for how comprehensive the presentation is, I think we really have got to move into areas where we have serious expectations around issues of implementation. And so with regard to the presentation, I have said that I fully appreciate it, and as well as the strides that are being made in order for us to, have ETAs, electronics, in order to be able to authorize properly within the system, as well as biometric verification. I'd like to hear from the department or the BMA. When will our country actually have a fully integrated entry-exit system to ensure that we automatically flag visa overstays instead of relying on enforcement operations months or years later? What is the plan with regards to that? Can we get a response to that particular question? And of course, we saw that, there have been, flagging of repeat offenders, as well as those who are declared undesirables. How many people deported this year had previously been deported? Are we able to tell that? And does the department, are you able to prevent repeat offenders from simply returning under different identities, given that there has been this huge understanding that there are documentation misrepresentations as well as fraud, and as well as corruption that is in the system. Another problem that we have, and we saw this now with the IMC, which was a fantastic collaboration between related departments. The question I have in this regard is, when will we have an integrated immigration database that will ensure that we communicate across departments in real time, so that people who are undocumented can't simply, disappear into other and different government systems? Because, this affects a lot of departments that include social development, health, and of course labor, as we have seen with the repatriation of various sectors of people who have been working in South Africa while undocumented. And then, of course, I think my final assertion, Chair, will be, whether the strategic outlook of the department is to really prevent, the migration of illegals into South Africa, and also, that we don't just respond to what is happening. While we fully appreciate what has happened in the last while, I just want to get a sense whether we are now moving into prevention, enforcement, rather than a response and a curing of the problem. I think I will leave my questions at that point, but I really just think that it's very important that we really move into a space where South Africans and those who are coming into the country can have confidence that what we're doing is just equitable and fair for all of those who are involved, because I don't think any of us want to have this kind of June 30th having to repeat itself over and over and over again, particularly for what this means for us as South Africans, across the continent as well as globally. Thank you, Chair.
Thank you, Honorable Ngobeni. Honorable Mkhale.
Thank you very much, Chair. Let me just start off with the initial question that was asked by Honorable Rose, I think, around how the department is going to ensure that individuals who have been deported do not re-enter the country again. I think that question, Chair, the reason why I'm interested is because we have asked that question before to the Minister, even in Parliament, in the question and answers session. And the Minister has not been very clear in terms of how the department is going to ensure that people who have been deported are unable to re-enter South Africa again. So I'm interested to hear his response coming from Honorable Rose. Chair, the issues we're dealing with, Chairperson, particularly centered around the events that have happened in the past couple of weeks. Chairperson, we must put the blame squarely into on the Department of Home Affairs, because this problem has been in the making for years. This problem has been in the making for years, Chairperson. We've had these xenophobic flare-ups over, close to almost 20 years now. That every once in a while there's going to be a major xenophobic flare up around issues of immigration, foreigners, and all of that, and the blame on Home Affairs is because they are the custodians of our borders. They are the ones who are responsible for people coming into our country and going from this country. So the blame, Chairperson, should really fall on the department. The June 30th deadline. I don't know if the department was working under pressure from the civic organizations. I don't know if I should call them civic organizations or what. Was the department working under pressure from those groupings that were marching all over the country, or what? Because it's very important for us to know if the department is being pressured or taking action because of pressure coming from civic organizations such as March and so on. Chairperson, the report also speaks to the foreign governments having to foot the bill. But what I want to know, check, is exactly what would they be paying for? What are they going to pay for? Because are they just paying for the cost of transportation, or they are paying for the overall costs involved in terms of taking care of those nationals and all of that, the food, the accommodation, and all the other related costs involved? Or are they just paying for the transportation costs, that is to bring those people back to their home countries? And also emanating from that is the role of foreign missions in terms of the verification process. I remember last time there was an issue with regard to some of the foreign missions that the department has tried to get involved in that process of verification, that they were not really forthcoming in terms of attending to the verification of their nationals at our holding centers like Lidnella. So I want to understand if has there been any improvement in that regard? Have these missions really assisted the department in terms of this process of verifying their citizens? Chairperson, the other issue is around the syndicates that we all know are the ones responsible in terms of bringing or facilitating the entrance of illegal immigrants into our country because of our porous borders. What sort of work is being done, intelligence-driven work, to deal decisively with these human trafficking syndicates? I remember a couple of months ago, we had an issue of Ethiopian teenagers that were found in one of our cities here in Gauteng. They were illegal into the country, and they were brought in here through these smuggling syndicates. So what work is being done in terms of dealing and dismantling and exposing these human trafficking syndicates that bring in children as small as 15 years into our country? So what work is being done to address that challenge? And also the SADC and continent-wide solution to this matter, because this is not just a South African problem. I think it requires the involvement of our neighboring states and the continent as a whole in terms of addressing the issues of illegal immigration. So, what have been the progress in that regard in terms of getting our fellow African states to get involved in getting a much more durable solution to these issues that we are dealing with internally in the country. And I know there's an upcoming SADC meeting. I'm not sure if the minister is involved, but maybe he will respond to that. And lastly, Chair, to the BMA, the body-worn cameras, I think last time the rollout was very limited. I'm not sure now currently if there's been additional procurement of these body-worn cameras in terms of ensuring that, there's proper monitoring of border officials at all material times. So has there been an increased number of these cameras, or are we still sitting at the same number? And even the rollout, is it, across all the points of entry, or is just limited? Thank you very much, Chair.
Thank you, members. I'm sure all of us have contributed. The few issues I have, and I think members have labored in all the critical areas. In relation to the BMA minister, I think we note the presentation, but it is clearer that the BMA on the ground is still working as a pilot. And I think we've labored around the underfunding for a period of time. It will appear that none of the executive members, and including the head of state, is paying more attention to the crisis that we may in future interface with. And it's a matter that we must raise with you as a deputy minister. I'm sure members who could not expose that your officials in the process of our observation there did not have just basic battery to move the tools that you're using. Were exposed to that environment. The staff who are processing movement of people there, they are not trained in terms of the standard procedure of processing the movement of people. We've seen it ourselves in the presence of your commissioners. The official who's controlling the drones and the head of police who were joining us there did indicate that the drones we're using are weak. In fact, are even intercepted by the drones that are used by the syndicates. And I'm sure you're aware that you have only 4 drones throughout the country. Your uniform of the guy who was controlling the drone, I think it was exposed to us. Members were asked whether this thing was bought, which year. So basic issues that must support and complement the work of the staff are not there because of resources that the department has been, the BMA been raising in the portfolio committee. And so there's no political will on the part of the executive and the head of state. And I think this we must raise it because it can't be a matter that the entire parliament consistently raise the issue of the Border Management Authority underfunding. And you talk about many things that need to be involved in terms of procuring when there's no money to deal with the basic training of your staff, officials throughout the entire value chain. It's a matter that we thought we must also raise it with you, and hope you'll raise it with cabinet. I think they even we took a posture that both the president and the minister of finance must do their physical oversight, site inspection in those borderlines, in Limbombo, and also in Bedbridge and any other land ports, so that you get a feel of what officials are dealing with on the ground. You have seen it when you're through the interministerial committee led by Minister Kubai. When you're going throughout the area there, how difficult for officials to assist to manage the borderlines, including facilitating the processing there because of funds. And this, I think members are raising that this emergency gave us an opportunity to know that resources are there to be allocated. There's no doubt about that. Resources are there to be allocated. But when there's a call for resources to be allocated, resources are not available. So it's a question that I think you need to grapple with in cabinet when you come back to the committee to deal with matters of the Border Management Authority. The other point which I think we may need to be exposed to at the level of the Home Affairs is the procurement process of all the areas that department was apportioned to do. What has been a movement from other portfolios within the budget allocated in order to complement the work of the repatriation center. And I think we'll require details from the chief financial officer in terms of the allocate how the process was undertaken so that we avoid, or even we will not avoid, but the committee is exposed to a potential risk of corrupt activities that might have been undertaken if they do exist in terms of the measures that have been taken, and or what are the measures you've put in place to strengthen, to avoid corrupt activities that may emerge later in terms of this process. And I think we'll need that part. The other point I think we the department, we know that you don't have enough immigration officers, even if those that you have advertised, 300 of them or so, are not enough to ground the work that is before us. I'm more interested on the number of Pakistans that are not highlighted in the main, particularly those that are owning what you call this puzzle shop throughout the country. Those that are legal or illegal. And I'm sure that you're able to, with your officers on the ground, able to determine that. And also other nationals. I'm raising this because when your team, the deputy ministers who have been exposed to Deputy Minister Njabulo, Nzunza, DM Bushelo, DM Hlengwa, DM Sbia, and others were conducting this unannounced monitoring or searches throughout the country. Part of the community who have been exposed were not being don't have papers, is this nationality. And I think it would be important that we grapple with that. And I'm not exonerating other nationals, but I'm saying the numbers that are reflected in all the nationals here, they may not reflect what society is identifying on the ground. So I think your report may need to expose us more on that. The other point is on the temporary movement of refugee centers to the ports of entry. Was the understanding of the pronouncement of the president indicated that the temporary movement of refugee center to Musina, it was only meant for this repatriation, or there's going to be a gradual movement to have a refugee centers in Musina, moving from Tshwane as it being pronounced by the president. And I know the fact that the redevelopment of port of entry will consolidate that fact. But what are the plans now that of movement of the repatriation center, I mean the refugee center to the port of entry? I fully agree with the members in terms of the involvement of member states in terms of the engagement around the subject matter, but also on the cost recovery in relation to what the department and other department has raised in terms of processing of members to other countries. We'll now invite the DG, the commissioner, and the minister to comment. DG.
Thank you, Chair, and thank you, honorable members, for the questions that have been raised. We truly appreciate. Maybe let me start with the questions that you have raised, also raised by other members, Chair. You will recall that some of the challenges, we won't be able to really address them outside issues related to infrastructure for the ports of entry. This committee has visited a number of ports of entry and identified that as a key risk, but as a priority. And to that extent, the IMC, probably during the course of this week or next week, will be making a formal submission to Cabinet for consideration of a CAB memo on the borderline infrastructure. And I think the Defence Force will speak to that when they do present. So there's work that's being done to address issues around infrastructure. Linked to that is your question around the refugee reception centers. You will recall that when the president addressed the nation on the 7th, he indicated that there should be a phased relocation. And our understanding is really around how do we consolidate what you currently have there and the one in Tshwane, but we are comfortable that the BMA, in our discussions with them, had indicated that within the parameters of the redevelopment of the 6 ports of entry, this work will be accommodated. So at the moment, we're dealing with a phased relocation of that. You're quite right, Chair, on the issues related to procurement. Our CFO is online as well. And at an opportune time, we should be able to share with you the process that was followed with regards to setting up the temporary repatriation facility. We followed up with a letter that we wrote to the Department of Public Works and Infrastructure, and they would have followed their own processes from that side. And similarly, the request to both eThekwini and the city of Cape Town, they would have followed their own processes from that side. And you'll recall that we were not providing food, Honorable Mohale, and accommodation was really in the temporary structures while people were waiting for buses to move them to their countries of origin. The food was through the NGOs that were really assisting us with regards to that. In terms of the capacitation, Chair, you're right, beyond the 301 inspectors, we have submitted a business case to National Treasury with regards to additional capacity that is required at Inspectorate, and we hope they will be able to consider that favorably. Equally, Chair, on the issue that you've raised with regards to the Pakistani nationals, you are aware that there is another IMC that is looking at foodborne disease, which is also coordinated through net joints. And at an opportune time, we can provide you with information with regards to those puzzle shops, the raids that are currently being conducted through that IMC, which is supported by net joints as well. And then with regards to the member states, the engagements are ongoing, Chair. As I indicated in the presentation, for the first time, for quite some time, the SADC foreign ministers had not met, and for the first time, they had a retreat in Skukuza, and amongst others, to discuss matters related to this matter led by Minister Lamola. And of course, he has been in Ghana, he has been in Nigeria, he has been in other parts of the continent, and I think the president has also sent envoys to a number of countries, including the delegation led by the Zulu King in Zimbabwe. So those are part of the efforts in terms of the various engagements with regards to the continent. As we've said in the presentation, we will not be able to address issues around migration if we do not, as a region, address the push and pull factors. And then with regards to Honorable Mokhali on the foreign governments in terms of costs, for now we are we've made a request through DERCO through an verbal for consideration of the transportation costs, because they were quite steep for us to a number of governments included are those where we've been deporting to. That will include Ethiopia, Nigeria, Malawi, Zimbabwe, to a lesser extent Mozambique, because they've been paying for their nationals. Zimbabwe has been paying for their nationals. Malawi paid for some, but the bulk were really provided for by South Africa. I think the commissioner of the BMA will speak to the syndicates, including the work that Net Joints is doing around dealing with those syndicates around human trafficking through the intelligence structures that are currently dealing with some of those issues. And then I think Honorable Ngubane, I've spoken to the cost recovery. We are waiting for DERCO to engage them. And I suppose from the discussions that we've had with DERCO, those note verbals have been sent to those countries. There's an issue that you raised, Honorable Ngubane, with regards to Point Road in Durban, Tshwane, Johannesburg, and Ekurhuleni. The IMC is continuing to do its work, and to that extent, the first focus following a meeting with all the mayors of Tshwane, Joburg, and Ekurhuleni, Net Joints is currently working on an operational plan with a view to target some of these, in particular the 3 cities where you have issues related to bad or problematic buildings, but also addressing issues related to immigration. So that work is ongoing. And then, of course, the chair of the IMC has also instructed that we need to meet with the other mayors of the other cities, which will include the mayor of eThekwini, to deal with the same issues that you have raised, Honorable Ngubane. I suppose on the border fence issue, I've responded to that, including by the commissioner of the BMA, that this work is being championed by the Minister of Defense as delegated by the IMC to look at the borderline infrastructure. Honorable Machi, how long? We have made a recommendation with regards to the temporary repatriation facility to the IMC. The IMC will make a recommendation or will make a decision. Safe to say that if you note, we have now started to scale down on those operations. There's no intention to make the temporary repatriation facility permanent. As indicated in the wording, it was a temporary facility that we had to set up to address an emerging challenge. I think Honorable Ross have spoken to what is it that we're doing to make sure that we do recover through DERCO funding that we have provided for transportation for most of these countries. And I suppose on the porous borders, there's work that's underway, as I indicated, for the borderline infrastructure. And then there's work that we have really done, and I think the Minister will speak to what we'll be doing tomorrow with regards to the launch of the ETA and the components thereof in terms of tracking those that normally would overstay. And from our side, we have been able to see that those that overstay and are really where we impose penalties in terms of the bans. We currently have more than 17,000 of foreign nationals that are asking for those overstay appeals to be uplifted. And obviously, we have to look at each and every reason for that. Honorable Ross, you also asked a question around the dedicated courts. The dedicated courts are currently being expanded. Lindela will probably two. Again, the architects there have from from DOJ, Department of Justice and Constitutional Developments, will be sharing later this week with the departments the plans to expand the Lindela court to have at least 2 courts. And then I indicated in the presentation that OR Tambo will have a fully fledged court based on the facility that we've been given. Again, the plans are well underway, and AXA will be ensuring that those courts are up and running. And we are of the view that given the urgent request and the performance by these courts, we should start seeing some of that work being completed before the end of the year. We have a team that's monitoring this work on a weekly basis together with AXA and Justice. And of course, the fingerprints that we took of those that have left will, of course, be onboarded on the ETA so that we're able to track as well. Suppose Honorable Mtolo, I've spoken to the issue around the push and pull factors that will require interventions at a continental but also at a regional level. And of course, we have said our approach is human rights based, aligned with the provisions of our constitution, the Ubuntu values, which are closely aligned with our Pan-Africanist approach. And I think the demographics we've been able to provide that on slide number 23. Honorable Mudisemte and Honorable Mtolo in terms of other nationalities. And for sure, if there's a request, we can provide further information. I suppose Honorable Palmer, the Commissioner will speak to issues around the 30-day, and then the issue with regards to the metro will investigate why there's no traction, because these matters are really supposed to be replicated at a provincial level and at a district level. The coordination is done at net joints and then at prof joints in the province. And then I suppose the financial implications, we had received an allocation, Honorable Mudisempia, of 60 million from CARA. We've now made submissions together with the BMA to the finance or to National Treasury for the unforeseen and unavoidable expenditure that currently we have had to incur. Thank you very much, Chairperson and honorable members.
Thank you very much, DG. Commissioner?
No, thanks, Chair. Honorable members for the questions. DG has given the overall questions. I will just talk specifically on those that are more port related. Honorable Ruos is asking about the standard operating procedures in terms of what I had indicated. We have started intensifying in terms of asking the travelers about what are they going to be doing to the country. Do they have money to sustain themselves? Where are they going to be staying and all of that? Yes, Honorable Ruos, through you, Chair, we have actually developed very strong standard operating procedure. And by the way, what we also did to make sure that there is a full alignment, just in the past week, between the 4th, the 3rd, the 4th, we actually had what we call the immigration indaba, where we brought in our operatives in the front line. We brought in the Department of Home Affairs as the policy custodian, and then we brought in other external stakeholders just to engage on this particular aspect and make sure that we do what is actually meant to be done, particularly in terms of the borderline. So yes, there is a very intensified SOP training that we are doing with our officials in the front end to make sure that we are fully aligned in as far as this particular aspect is concerned. As I've indicated, we had perfected it in terms of the airports, but in terms of the land port, there has been that bit of leniency. And that leniency did not just start with the BMA, but it is something that had fairly been inherited even from the 1st of April 2023. So that is part of doing border management differently. And hence, we had to be making sure that in case there might be some complaints, it has to be properly canvassed with the rest of the ecosystem to make sure that there is a possible explanation, even if it gets to be a political issue. In terms of the other issue, Honorable Ruos had asked about the work around the transfer of the border police. I suppose the minister will be able to reflect on that. It is something that is sitting at that level, at the political level. Technically, the stalemate has actually been sustained up to this point, and that remains as a point. Now, the issue of the return strategy, let me indicate in one of the key slides, I had actually demonstrated how we had actually requested additional police to be brought into the port to assist us in terms of taking care of the vulnerable segments. Additional to that, we have requested additional members of the SANDF who are from Operation Corona, but even additional out of that environment to assist us to deal with the return issue. In other words, to make sure that the people that has been exited do not necessarily walk back into the country through the vulnerable segments. I did indicate, for example, that we even have 63 that we have sent to our borders with Namibia, an area that had always not been problematic, but intelligence has started to tell us that there has been a diversion of individuals, particularly from the north, going via the Namibia side. Hence, we are proactively deploying in that particular area. So I'm just saying that that is what has been agreed upon at the broader NAT joints level to make sure that people do not return into the country using these vulnerable segments. As the Border Management Authority, in as much as we can mandate legally, but it is clear that with the 600 border guards, we will not be able to do the work. And that is why we have requested other system law enforcement structures to come and make sure that we actually implement our counter-return strategy. The strategy is there. It is very much clear. The only issue, obviously, is the capacity. Hence, we had to be assisted to make sure that we do exactly that. The rest of the other issues is around the issue of the barrier, and the DG has spoken very explicitly on that we consider to be the long-term approach. Once you have some bit of barriers in this vulnerable segment, you will definitely be able to do some countering in some of these vulnerabilities. So I think that is basically the response on that. In terms of Honorable Mtolo, the DG had responded on this particular aspect. I think the only thing that I can just add is the fact that we wouldn't easily, as a jurisdiction, be able to go force other countries on the other side to deal with the push factors. We can have diplomatic conversations as they have been unfolding, but those realities still sustains. Now, for us as a country, we then need to look at the pull factors from our side. And I think the other aspects is the fact that our economy is seen to be strong as a pull factor. We can't do anything about it. We can't make our economy to collapse to deal with the pull factor. Similarly, if our infrastructure is seen to be more advanced, we can't undo our infrastructure. But what has been implemented as a strategy is to make sure that employers are discouraged from hiring illegal people. And that is why the new approach, you have seen it being implemented, is that if you are found to be employing illegal people, you yourself get arrested. That is the attempt to deal with the pull factors. And I suppose that is going to go a long way in assisting in as far as that part is concerned. I think that is also reflecting on the issues that Honorable Modolo had indicated. In terms of what Honorable Bolman is talking to, I think this is one thing that is very much practical. The fact that within SADC itself, there has been this agreement that we will be traveling to each other visa-free, and they agreed on either days, on either 60 days, or on either 90 days. But those particular days, as they are being given, are mainly for visitation purposes. And we know in our instance, the problem has been people have been using those particular days to ultimately abuse the existing system and be able to come to the country, overstay, and that has always been a vicious cycle. So what are we then doing? I think what we can talk to here, Honorable Bolman, through you, Chair, is two things. Number one, in terms of the long term, it is going to be an assistance we will get from a rolled out EMCS 2.0, because EMCS 2.0 is going to be an automated mechanism that will also assist us to send messages to the travelers as soon as their days are about to expire, to say, you have 3 days left, do not forget to exit the country. This is a mechanism that is deployed in other jurisdictions, especially when they have a very robust system that is automated. So that is the long term. But in the meantime, we are countering this by making sure that even these particular individuals, as they come through into our country, we need to do some further conversation, as I've indicated with the new SOP, to say you are intending to visit South Africa. What is the purpose of your visit? Are you coming, for example, to buy groceries, as an example, or you are coming to a particular environment? Is it a one-day visit, or are you going to stay? If so, where are you going to be staying? Are you booked in a hotel? Do you have money to sustain yourself? And arising from that, we are then able to make a discretion in instances where somebody is actually taking chances and be able to deny entry. That is why, as I've indicated, over 12,000 just in the past 3 months had been actually denied because of the same reality. And those are some of the interventions that we are putting on the table in the meantime, while we are still to roll out the system to be able to deal with these particular issues. So that is basically the essence. But there is not going to be any possible shift around this thing of moving to each other with this visa-free entry of 90 days, 30 days, and all of that, because that has been part of what has been embedded in the protocols around the movement of persons, but also to make sure that there is better intra-Africa trade and all of those kind of issues. So I think on that basis, we can agree that those are the issues that are being dealt with. Now, in terms of the issues that Honorable Modise had spoken to, I think, Honorable Modise, it is good that as the committee, you have been on the ground, you have been able to see the issues that we've been talking about in this committee almost for the past 3 years. And these are very much real issues. And on that particular basis, we are then able to also see that even ourselves, from a leadership perspective, it becomes very much difficult when we get to the ground and see the struggles of the colleagues on the ground, but we are not able to do certain things just because of the underfunding reality. The issue that the chair had spoken about in terms of the uniforms of the colleagues, it is not a theoretical issue per se. It is good to have seen it. But the last time we were able to give some of the conventional border guards the uniform was in 2022. That was in June when they were actually launched at the time. And that was the only time. And we couldn't be able to do the refresh. And that has been the unfortunate reality, just because of the same issue that we don't have much operational budget to be able to run the entity. And I think that part has been well canvassed. I wouldn't want to take more time on that. I suppose the minister, as the chair had been asking, will be able to reflect a bit in as far as that part is concerned. Now, you are asking Honorable Modise about whether has there been any additional CARA allocation to the BMA. I can actually confirm that when we started in 2023, you will remember, Honorable Chair, we have requested 500 million, and that was to be the money that we actually wanted to assist us to buy the tools of trade and all of those kind of issues. And we got 150 million. That is the money that enabled us to even buy the uniform for the 400 junior border guards that we had to employ, as well as the vehicles, including the tools of trade. You will remember the border guards, the junior border guards operated for almost 12 months with no tools of trade. And I can explicitly indicate I'm talking here about guns and ammunition. And we had to use that money to be able to procure those, hence they were delivered a year after. And that is why today you will see that they are actually armed as they are supposed to be. Now, because we applied 500 million at the time we got 150, we do know at the same time we applied, I think the police got about 2 billion, and I think defense got some other big money and all. So we then thought that maybe we need to apply for higher money so that at least we can get something. And that is why we applied for 3 billion just in the last cycle of last year. And I think you are aware by now that we're at least able to secure only 50 million out of that application. And on that particular basis, that 50 million is what we are busy trying to use now, at least to do some bit of procuring of some other key tools of trade in the current financial year. From an operational budget perspective, I think that one is well articulated. That is not there. Hence, we are fairly struggling. So that is basically where we are on the issues of CARA, honorable members. Honorable Ngubane, you had asked again the issue around the vulnerable areas. I suppose you ask a question in two ways. Is the vulnerable segments, which I've responded to, but the one about internal, the issues about Pretoria and other places, I suppose those are the issues that the DG had spoken about in terms of the inspectorate that works internally. But let me address the issue about the SIU in relation to the border fence. You will remember that the DPWI, the Department of Public Works and Infrastructure, did spend the 40 million in trying to build the border fence around the COVID time. And we know by now that that was a very substandard issue, and that is why the SIU took that particular company into the tribunal. They won the case, and that company was meant to give that 40 million back to the state so that it can be used in as far as the reconstruction of the proper border fence is concerned. That particular company took the SIU through the system until the Constitutional Court. And just in the past 3 weeks, they actually lost at the Constitutional Court. As we speak now, the SIU is busy trying to retrieve that money back to the state. And that is the money that will serve as the first deposit in this particular work that we have spoken about, which the Minister of Defense is working on to make sure that we have some kind of a barrier. So that is that in as far as that part is concerned. So the issue around the V listing, yes, when we have V listed people, when they attempt to re-enter the country, the hit actually comes through our system and we are actually able to deny entry. And once again, you will see with those denials, some of those denials are the people that had been V listed that actually are not allowed to enter the country for the next 5 years. But of course, some of them are those ones that are busy appealing, as the DG had indicated. In terms of Honorable Ngobeni, the issue that you had been asking, so you also asked about the issue of the days, and you are asking about the tracking, and I think I've responded to that in terms of the future state as well as in terms of the current state. So the flagging of the repeat offenders. By the way, in the Indaba, one of the key issues that came out is that this thing of delisting people, and then we keep V-listing when they come back and all of those, and they are found in the country illegally. It is actually a cycle that does not end. Part of the recommendations going forward is to also introduce some kind of a charge so that if somebody is a repeat offender, we must also be able to V-list them, but also be able to charge them for them to be able to pay. But those are issues that are being deliberated on, and ultimately they will be put through into regulations as we go forward to try and deal with those particular aspects. But for now, at the end of the day, the only thing that we are doing is to be making sure that we at least avoid for them from coming through into the country, which is one of the most critical aspect. Your observations, once again, Honorable Ngobeni, has been very much spot on the ground. Let me conclude, Chair, by reflecting on the issues raised by Honorable Mohali. Honorable Mohali, the issue of the what you call facilitators has always been one of the biggest problems. And I can confirm that the drones had been assisting us to identify the facilitators, and we've been able to take them down in a way. And remember, we don't deport facilitators. For the past 2 years, we're talking about 150, and then we moved to 138. But now we talk about 760 that we have actually arrested. Not only facilitators, but among them, there are facilitators. So what we are doing with facilitators is to take them out of the business and make sure that at least we are able to arrest the situation. Most of the individuals will not be able to move themselves through those particular bushes, except that they get facilitated. And those are the kind of issues that we are effectively dealing with. You have also asked whether do we have any additional body-worn cameras that we have added. Once again, Honorable Chair, we only have the 40 body cams that we introduced last year in April in 2025, and we have not been able to add any body cams. And once again, it defaults back to the same financial issues. And of course, with the 50 million that I've spoken to, there will be some element of it that will be used to try and get additional body cams. But up to this point, as we speak, is only the 40 that were procured last year, as indicated, and we have not been able to add any additional ones up to that point. So, Honorable Chair, I think the questions that you had asked are fairly covered, and I think most of them were directed to the Minister. The only thing that I can just say based on your point, Honorable Chair, is the issue of your observations on the ground, the issue of the struggles we have even in terms of the tools of trade, and we have given the example regarding the issue of the battery, which is indeed a fact, and those are the issues that are very much challenging as we continue to do the work on the ground. However, we are aware that there is some bit of traction to be able to look at the possible funding of the ecosystem as we go to the future, and we should be able to deal with the issues that we are meant to deal with. There is no shortage of plans in terms of how the future state of border management in South Africa needs to look like. The only qualifying common denominator has just been the funding issue. And once we are able to bridge that gap, we should be able to start having a better environment going forward. Thanks, Chair and committee members, in terms of the questions raised. Thanks.
Thank you, Commissioner. Minister.
Thank you very much, Honourable Chairperson and members, as well as the officials for those presentations and responses. Chair, I see a hand is up. I don't know if it might be before I come in.
Okay, thank you. Let me check. Honourable Ngobeni.
Thank you, Chair. No, I just wanted to find out if, the question that I asked around that particular official was not answered. I don't feel that it was answered by the commissioner. He just said, it's well noted, but he did not respond. I asked what has happened to that official because we all experienced it. And so it's not something that is hypothetical. Can we please get a response to that? Thank you.
Thank you, Commissioner.
Apologies, Chair, and apologies, Honorable Ngobeni. It's just that I've been trying to move a bit faster on the issues. I actually jumped to that point. Yes, that particular officials has been dealt with, and what we ultimately did on the basis of what happened, we gave that particular official a written warning on the basis of what transpired. And maybe let me also put it this way. One of the reasons why there was some leniency is on the basis that that issue actually happened when the training in terms of the new SOP has been rolling. In other words, we've been busy actually training the officials, and the team on the ground also did confirm that even the communique or the communication or the instruction that has been sent out has been well canvassed and communicated with the rest of the team, and that included that particular official. But on the basis that this thing happened whilst the training is busy rolling, there was a bit of leniency. However, the person did go through the normal HR processes, and it then led into a written warning. One thing that we communicated is that once all people are fully trained on this particular approach, should anybody be found flouting the SOPs as put together, there is going to be more hectic consequences going forward. And apologies for jumping the question, Honorable Chair. Thanks.
Thank you very much, Commissioner. Let me invite the Minister.
No, thank you. Thank you very much, Chair. Just looking at my notes, I would not want to repeat most of the substantive issues that have been covered. So let me just see where I can add some value. Firstly, on the border fencing issue, it is without a doubt the one big outstanding issue that would really assist the reform journey that we are on. And as the DG has indicated, it is being led by Defence in terms of the IMC process. And what I can assure colleagues is that from the side of Home Affairs and this ecosystem, we are in full support of that work that is underway. And we fully agree that this is really a critical area that demands investment going forward. Chair, I want to touch on, related to that, I suppose, the resourcing issue that has been raised repeatedly, including specifically for the BMA. Safe to say that the budget process and the cabinet process there, the submissions there from our side are robust and ongoing. I think even when you hear the scale of requests that the BMA is submitting, even to something like CARA, this is being taken with the utmost seriousness. However, it is obviously not for the Minister of Home Affairs to individually approve the budget requests. It is part of that broader collective. And the work that we are doing there is absolutely to make the case on an ongoing basis for why these investments are so critical. So there's no dispute around how critical they are. I suppose in any budgeting process, the question that we have to answer collectively is, if we are going to adequately fund not only the BMA, but potentially also the border fence infrastructure, etc., then where are the trade-offs going to be? And that is the issue that I feel needs to be confronted in a more head-on and direct manner, because we have to be able to answer that question. And I think there are members of Parliament that ultimately approve the budget, and I would really invite that discussion for us as a collective to say, where are we not only going to fund and increase the funding that is so desperately needed, and which is a good investment for South Africa, as I've also repeatedly said, but where are we prepared to actually then make the cuts that fund those interventions? And that is the nub of the issue, Chair, as far as I can discern. It's not that there's disagreement on how important this funding is. It is an issue of prioritizing and saying, on where are you going to cut on the other side? And that's where people have disagreements. And even if this committee were to actually debate that, I'm sure there would be many disagreements on where that needs to happen. But that's the reality. That is the question that we need to answer. It's the question the executive needs to answer, but it's also the question that Parliament needs to answer as the ultimate sign-off authority on the budget. And I think we all have a role to play in that regard. I can tell you, Chair, the repeated visits I've had to the borderline, as well as the time I spent really living there while this temporary facility was going up. You're preaching to the choir, as the saying goes, that it is not people on this call who need to be persuaded about the critical need for this, the way in which the infrastructure has been allowed to dilapidate across that border fence. This is where our hand needs to be strengthened, as well as the BMA as an institution. So I am hopeful that this focus that there is now through the IMC and Defence leading that process on the border fence can yield some results which get us moving on this particular issue. It is really a top priority that will enable and take pressure off the BMA and Home Affairs in so many ways. So that is really our perspective on that. And the issue of SAPS and border policing again, Chair, has come up as usual. The last engagement that we had with the Minister of Police and colleagues was really to say then, if there's not going to be a transfer of personnel, then how is police going to assist the BMA to actually employ additional personnel in and of itself? And the commitment in that discussion is that there will be a collective approach in strengthening the hand of the BMA through these budget making and cabinet processes, Chair. So that is where the rubber will meet the road, and we will rely on colleagues to really take hands with us and say that the issue of the BMA having only 600 border guards and all of the issues that you've described around everything from uniforms to tools of trade is something that we as a collective have to address, whether it's through the transfer of individuals or through a straight up budget allocation increase to the BMA. I don't think at the end of the day is determinative. What matters to us is to get resources and boots on the ground. That is the key metric, and that's where the conversation currently is as it relates to SAPS. Chair, the question of working under pressure, I do want to just touch on this. The ETA is a very good example of the fact that this work has been proactive from day one. You can't develop a system like that because of an arbitrary date or anything like that being issued. It has taken us 2 years to build the infrastructure of what is a world-class digital solution for immigration. And that's what we will be then launching tomorrow. And I think once colleagues see this system in action, you will understand just the scale of the work it has taken over a 2-year period to build, or conceptualize, build, and roll this out. So that is work that is ongoing and has been proactive and ongoing really since the start. Linked to that question, Chair, I think is, as Commissioner has touched on, the issue of preventing re-entry, etc. I do want to maybe merge that question with Honourable Nkubeni's question around when will a fully integrated entry and exit system be rolled out? And I think she also asked, when will we have a fully integrated immigration database? I think all of those issues, Chair, are answered through the ETA. And it is most definitely the intention, and we are on track to deliver exactly those things by the end of this administration. Beyond that, what we will be launching tomorrow is an entry and exit system that is truly world-class. And I was reading an interesting piece in the Financial Times this morning on an entry-exit system that was rolled out in Europe and some of the challenges and design issues that they are facing. And it was such a great relief because some of those issues we have deliberately actually resolved in the design. So I'm really impressing upon colleagues and members of this committee to take a look at this work and what we will be demonstrating and launching tomorrow, and to see how it resolves so many of these problems across the board. Firstly, it indeed will scale into the integrated immigration database so that we have this one interoperable system that is able to do what we call a foreigner status verification. Members will know that we have online verification service for citizens that we use in many parts of the economy. And what we are building really through the Intelligent Population Register and the ETA is verification functionality that will go into the space of foreign nationals as well, which will be an enormous multiplier and powerful enforcement tool as we move forward, because it enables biometric verification of immigration status. So the ETA is foundational to that, but more so the entry and exit component specifically. Without giving too much away, this is one of the fundamental elements that we will be rolling out tomorrow. because we now have a biometric-based entry and exit system. We will know when someone's face has entered South Africa. We will have all of their information on file, so that if that face is not recorded exiting South Africa within the prescribed period, we are able to actually contact that person, alert that person. They will know that for the first time, Home Affairs is watching each and every such case, and of course, take enforcement action where required in a much more efficient manner. And that is exactly what we will be demonstrating tomorrow. So I think, colleagues, perhaps to say, Chair and members, that amidst the challenges and challenges that have accumulated over time that we are confronting, I think specifically as it relates to this presentation on repatriations, but also more broadly in terms of system-wide challenges, that the fruits of the focus on digital transformation is really imminent and something that will stand us in very good stead. And the commitment certainly is there, Chair, to ensure that all those systems, as Honourable Ngubeni articulated them, will certainly be in place by the end of this administration. And tomorrow will be a very important, probably the most important milestone so far on that particular journey. It starts with tourism, tourists and short stay visitors, and airports, and then it expands into your other visa categories, things like study visas, where we've had many challenges over the years, as well as into your land borders, ensuring all of that becomes biometrically based and rolled out through this automated and digital infrastructure. So that is really the answer, Chair, I think, to the fundamental question that a number of members asked about the plan and the vision. And I do hope that some of the colleagues can join us tomorrow to see the President really take us through and launch this particular innovation. Thank you very much.
Thank you very much, Minister. Thanks, colleagues, for interacting with the presentations and noting the issues. We have come to the conclusion of our meeting. We note that the committee will further engage the parliamentary legal team and also engage the stakeholders that made submissions around the issue relating to the Immigration Advisory Board member in relation to the possible existence of a conflict of interest. We've made a time frame for before end of August to deal with that matter. In fact, on the next MENCO, we'll table that to process for purpose of the committee conversation around this matter. Secondly, is that the committee considered to defer the private members bill, MOD, and members have raised some of the issues that once adopted to be subjected to public comments. Members of the committee and also South Africans will interface with this matter. Will also receive a comment from the IEC and the Demarcation Board once that process has been concluded, and a response from the initiator of the private members bill should the committee consider to proceed with the committee. These are the steps that will be undertaken once once the committee deal with this matter. The committee take notes that the matter is still with the courts, but they've allowed Parliament to interface with this matter. We are going to also, as we agree, that the committee will allow the CFO in our next engagement. The team will be scheduling just to detail the procurement process that will involve in the Immigration Repatriation Center in Musina in relation to the details of service, so that we note the measures that we put in place by the department. We know that it was involved of various departments, but there are areas that affect our budgets in terms of the issue. So the CFO will take us through which allocation has been moved to cover up the work that has been done in the repatriation center. We hope that at that point we'll also establish the contributions of other spheres of government. I note that the eThekwini provincial government of KwaZulu-Natal, provincial government of Limpopo, and the municipality of Messina, to what extent costs have been associated with the work that has been done by the Interministerial Committee. Obviously, we'll wait a comprehensive report by the team that's led by Minister Kubai and your collective within the security cluster committees. But where Home Affairs has been involved in directives, will deal with that. We're happy that the outcome of the SIU report in relation to defense involved the public works has came to finality. And I think the process that the commissioner has articulated will monitor that. Minister, DM, and the DG and the commissioner want to take this opportunity to thank members of the committee, I mean yourselves, and all the issues that we've interacted with, particularly on the migration landscape that we're dealing with. The committee will be seized to deal with that and have a conversation from time to time with the team to make sure that all the issues, but also the work that we are conducting as oversight body have been exerted. Is there any other comment before we close? On Makhala, I see your hand.
Oh, thank you, Chair. No, it's not related to the matters that have been discussed, Chairperson. It's just a reminder, Chair, and just also to check with you, because last time we did an oversight at the facilities here in Tshwane, and there was supposed to have been a report submitted by the department after a 60-day period. And I think that 60-day period has since lapsed. And I've not seen or received any communication in terms of whether this matter is going to be on the agenda in this term. Thank you, Chair.
I'm sure you mean for the visit at the
That digital
okay.
hub. Yeah.
Okay. No, I think note that DG, we're going to rework our program in our main committee, because the items that have been shifted, and you know that we have not been dealing with the issues last week or so. It's not only that matter, it's only also the matter that of Dr. Lubisi in relation to the government printing work. So we'll note that Ola Makhale in our main call will try to rework the agenda. In the next meeting, we'll update members on the proposed revised agenda and how we think committee may need to consider the agenda. Thanks very much, members. The meeting stand adjourned for next to attend the plenary. Thanks very much.
Thanks, everyone. Good afternoon.
Thank you very much, Chair. Bye-bye.